Number 5 of today's list. What is the appeal was prepared by the department? We have to obtain instruction. Lordship, the matter was listed for Chief Justice Court. But court is directed to obtain some instruction. Lordship, I required for the 2 weeks time to appeal is yet to be admitted, not admitted.
Whether it can be admitted.
Lordship, because Lordship, the point here is there are 2 points were decided by CC 26 A's. But Lordship, there is no judgment from any High Court or Supreme Court, Lordship. But CSET's order, they are different. CSET passed that the no demand can be raised on basis of section 26 A's.
Correct. On the paper, a gentleman made for by Mr. Sikal. To submit that he has got to provide some more detail,
Lordship.
some more information with regard to the. This is the matter.
After 2 weeks.
You did.
Lordship.
Maybe. I beg to mention item number 1. I may be allowed to withdraw, Lordship. It become infractions.
Yes. Correct. The period has tendency has also gone.
It is also, and we are also dispossessed. So only our limited prayer was to extend some time, Lordship.
Right.
That interest.
Mr. L.R. Mazumdar, learned counsel for the petitioners. Says that he may be allowed to withdraw the writ petition as the same has become infracted. The prayer of Mr. L.R. Mazumdar is allowed. This petition dismissed as infracted.
Of like,
May it please your Lordship. Lordship, I beg to mention for listing, Lordship, a review petition, my Lord, which I have filed yesterday, my Lord. This is a review petition, my Lord, challenging a writ appeal order, my Lord, dated 7/8/2025, recent, my Lord. So, my Lord, this matter may come up, my Lord, tomorrow if the chief, the DB1 is constituted, my Lord, if it can come up.
Well,
There's some urgency,
no,
my
I
Lord,
think
it's a
next week, Monday.
Monday, my Lord, but there is a urgency because of the fact that, my Lord, we had a stay in that order. But then what happened was, my Lord, we had the petitioners come to know that the posts which were where we had got stay, those posts are going to be filled up. If it is not
Holiday, nothing will happen.
My
We'll
Lord,
list it straight away on
Monday, or tomorrow, or Monday, my Lord.
tomorrow's
Tomorrow, if the Chief Justice and the, my Lord, if the each of these benches there, my Lord. Or otherwise on Monday, my Lord. If possible, tomorrow, my Lord. On some urgency.
26.
My Lord?
20, yeah, not 26, sorry. On
Monday, my Lord. 18th is, my Lord,
18th is Monday.
Monday.
It's Monday.
Monday. Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 24. I have taken consent from the other side.
Yes.
Lordship, I required some time to file affidavit in reply against the affidavit filed by the respondent number 2. Lordship, we have received affidavit yesterday.
Item 24.
Yes, Lordship.
Your father,
I'm for the petitioner.
affidavit reply file. You will file.
No, Lordship.
We file, they received copy yesterday.
Yes, Lordship.
They received the copy yesterday.
They received copy of what?
Affidavit filed by the Indian Medical Commission.
Respondent number.
So what do you want to file to that?
So we have, Lordship filed, we'll file affidavit in reply against the
Your father petitioner.
petitioner. Yes, Lordship.
Okay, Miss
H. Bora.
H. Bora. Actually, it says D. Bora out there. It's
H. Bora.
Miss H. Bora, learned counsel for the H. Bora, learned counsel for the petitioner. Is submits that she'll be filing an affidavit in reply to the affidavit filed by the
Respondent number 2.
file number 2. Within
Within 10 days.
10 days, list the matter. Give it.
I am appealing for respondent number 2.
Mr. SCKL, except for file number.
Much of.
God bless you.
May I please, Your Lordship? I'd like to mention item number 6, Your Lordship. The engaged counsel that D. Sharma is having some difficulties today, Your Lordship.
Item 6.
Yes, Your Lordship. And it fix after 3 weeks, Your Lordship.
Your father petitioner?
Yes,
Is the departmental proceeding pending or what? What is this?
she has been suspended, Your
I
Lordship.
know, but is there a departmental proceeding pending against him? No. He's been suspended and transferred. Correct?
Yes, Your Lordship.
That is because of that road accident.
Yes, Your Lordship.
So what do you want?
Adjournment today, Your Lordship.
Why?
Because the The brief is with Mr. D. Sharma, your lordship, and he has some difficulties today.
D Sharma.
Yes, your lordship.
D Sharma, where is he?
He is having a difficulty. Yes, your lordship. Water logging will start there.
Okay, right. A general prayer has been made on behalf of Mr. D Sharma, learned counsel for the petitioner due to water logging. This is the matter. Next week,
After 2 weeks, your lordship.
right? This is a small issue, whether the transfer is punitive or not, that's all.
Next week, your lordship.
Actually, you don't want to do the case. That's the only thing. You should be in a hurry to have your case heard and disposed of. But you don't want to do it.
Any day.
Actually, he's going to be absent on that date also, next week. This is the matter, give it.
Oblige, your lordship.
Your lordship, I beg to mention item number 11 for admission.
Item
My-
number 11, yes.
My senior is out of station, so kindly adjournment. goes to there.
On the prayer for adjournment made on behalf of Mr. J.K. Goswami, who is apparently out of state. This is the matter. After, so we give a date. Next. What to do? For whom?
And for the state.
Yeah, for the state.
My lord.
They've got nothing to do here.
My lord.
No role to play.
My lord.
It's only, I think, between Canara Bank and
Canara
PNB.
Bank and Punjab National Bank.
Who has been given the loan first,
India given, yes.
right? No one appears for the petitioner. Accordingly, leave this matter in the next, this is the matter on, give a date. Next.
Alright. May I please? Lordship, this matter relates to Hindi teacher and this the Praveen and Ratna. But some of the candidate, as per this advertisement, that Lordship has got the advertisement of 27th December 2023. Lordship, kindly have a look at page 17, my lord.
Page,
Page 17. Page 17, this advertisement, this para lordship,
17, there is no advertisement. Page 17.
No, that-
Of your arithmetic.
it's a this paragraph 3 starts.
Sir, come to the advertisement.
Lordship.
23, straight away, come there. Why
Lordship
you-
will find advertisement starts from 73, my lord. This photostat this type copy at 73. Start from 73
Yes,
and the condition of recruitment 74. Lord.
this advertisement is for what?
Advertisement for graduate teacher,
For graduate teacher.
arts, science, Sanskrit and Hindi, my lord.
At the end of the day, it is for graduate teachers.
Lordship.
Then,
But their this stream is different. Hindi, Sanskrit,
maybe.
Lordship. Just I'm reading my lord first part. This application are invited from the eligible Indian citizen as defined in Article 5 to 8 of the Constitution of India and permanent resident so and so. Filling up 7,249 posts. Number 1, graduate teacher arts. Number 2, graduate teacher science, graduate teacher Hindi, and graduate teacher Sanskrit. Now I'm concerned with the Hindi, my lord. The 74 lordship will see the conditions, my lord, in the advertisement.
Yes,
We are agreed by these conditions, my lord. That is why this advertisement,
agreed with this condition, why?
my lord, this minimum education so and so. Praveen Ratna in Hindi with 50%, Lordship has got it.
This is,
Praveen Ratna in Hindi with 50% marks and degree qualification with 50% marks, or postgraduate degree in arts with 50% marks from any recognized university, or BA with 50% marks and having Hindi as one of the subjects
now,
with
now, Mr.
now,
You are aggrieved with this page 74.
Lordship,
You are aggrieved with page 74.
74.
At
Seven-
B1.
Yes,
You are aggrieved
Now-
with B1.
yes,
Come to your prayer. Come to your prayer.
Lordship.
Come to your prayer.
Yes.
Page 29.
Yes.
Where is your prayer to set aside this B1 of this advertisement of March
This,
20?
this Lordship will see, start from A, my lord.
Yes, I know. Start from me. Then come
This-
which is the provision?
Provisions,
Which prayer? A, B, C, D, which one? Which
my lord, A. A. I'm reading from A, my lord.
you go
Yes.
straight to that
Under
advertisement.
Rule 10 of Schedule 3 of the Assam Secondary Education Provincial and Service Rules 2018, which states, this rule is also a challenge, my lord, which states the Praveen Ratna as equivalent to Bachelor of Arts, having Hindi as one of the subject or major in Hindi as irrational and unconstitutional and ultra-virus. Then set aside and quash the impugn provision under Rule 10B and Schedule 3 of Assam Secondary Education Provincial Service Rules 2018, which states Praveen Ratna as equivalent to Bachelor of Arts, having Hindi as one of the subject or major in Hindi as irrational and unconstitutional. 3. Direct command respondents to amend, modify, repeal, revoke the recent and impugn provisions under Rule 10 of Schedule 3 of Assam Secondary Education Provincialization Schools Service Rules 2018, which states Praveen Ratna as equivalent to Bachelor of Arts, having Hindi as one of the subject or major in Hindi as irrational, unconstitutional, and ultra-virus. Set aside was the impugn advertisement. I dated census 27/12/2020.
This page 73 is not 2712.
Yes, 27.
No, you said 27.3.
No, 27/12. my lord.
Page 73 is which advertisement? Please look. That is what you said.
No.
Is-
Page 73,
Yeah.
Lordship,
Is 27?
yes,
Okay.
Lordship,
Okay,
find
then-
the original advertisement, Lordship will find at 75, my lord,
Okay. 2712.
12,
So
2020,
please, you see, when you make a statement, please be very careful of the date.
Lordship.
I was under the impression that this was under 27.3. Okay, 27.
Now, my lord, since only on the basis of the advertisement as well as on the basis of the rules, some of the
Let us see the rules. Let us see
rules,
this.
rules, kindly Lordship,
Let us
have a
see
look.
Rule 10.
Yes. Lordship, it starts from this 78, the typing copy 78, the relevant portion 79, Lordship.
Yes,
The rules provides for Schedule 3, my lord. Rules 10.
yes.
Minimum educational and professional qualification for direct recruitment in the post of Hindi teacher. Praveen Ratna in Hindi with 50% marks and degree qualification with 50% or postgraduate degree in arts with 50% marks from any recognized university. But degree obtained from off-campus and distance education institution shall not be considered as valid. Malat or BA with 50% marks and having Hindi as one of the subjects with 50% marks or postgraduate degree in arts with 50% marks, provided that he has passed BA with one of the subject as Hindi with 50% marks in Hindi. Malat here and BT/BA degree from any recognized university Parangat to be treated as BA so for the purpose of his choice, but degree obtained from off-campus and distance education institution shall not be considered as valid. Here we are, these candidates are the full-fledged 3 years degree course, my lord. We are. having the major degree. And also we have passed the master in Hindi. Malad, that is why now Lordship will the schedule, which has already been said, Malad, first Lordship will see the Rule 10. Rule 10 as at page 93.
Schedule at page 79, minimum educational qualification and professional qualification for direct recruitment in the post of Hindi teacher. You mean this is a graduate Hindi teacher?
Hindi teacher, graduate Hindi teacher.
For graduate Hindi teacher.
Yes.
Then what is wrong with the advertisement?
No, here wrong is my lord. We are that is why, my lord, the Ratna or Praveen is a 1-year course, my lord, certificate course, like diploma. My lord. So, my lord, we are the major course, my lord. We have the major course, my lord, the Hindi major course. There are vast difference. We have only 3 years full-fledged course, my lord. And this Ratna or this Praveen is only 1-year course. That is, my lord, and in 1 year, they will complete it. But
What is the name of your course?
this is, we are studying.
I
This-
think you are saying that these persons cannot be allowed to participate. Is that your
Yes. Because they cannot teach properly, because unless having this degree, these qualifications, how a teacher will teach a person only because certificate course they have obtained and they will teach in the schools, then the pupils will be totally damaged at large, because they do not know anything about this whatever the degree course Hindi was taught. In the certificate course, that may not be. And that is why, my lord, as a whole, we have challenged these rules as well as the advertisement. Whereas, my lord, Lordship will find in the upper primary school, this Praveen and this Ratna has not been allowed, upper primary. And even subject teacher, for subject teacher, it has not been said that you have to obtain Praveen or Ratna. If in the ME school or higher secondary school, if Praveen or this Ratna is not allowed, why in the graduate teacher, my lord? This is totally discrimination. And this certificate course, they cannot teach properly to the pupils, and it will be deemed to be damage to the pupils. And that is why even Lordship will,
this advertisement at 126?
yes,
This provides for Praveen and Ratna.
no, this is 126 is a advertisement, my lord, regarding postgraduate teacher.
Okay. Out here they're not. Out here they do not. They're not qualified.
No, regarding Ratna or etc., they have it has not been mentioned. And even in the case of primary school, Lordship, at page,
You are what? For what? You have got what qualification?
I have got the BA with major in Hindi. And even I have passed the MA in Hindi. That is why even in primary school, Lordship, at this upper primary at page 123, Lordship. Annexure 5 at page 123, my lord.
Yes.
The relevant portion 124, my lord. Hindi teacher for upper primary school. Lordship has got it. Higher secondary, senior secondary, or its equivalent. Graduate with Hindi as one of the subject from the UGC recognized university. And 2-year diploma in elementary education by whatever name known. Bachelor of Education or Bachelor of Elementary Education, and Assam TET or Central TET for upper primary school, non-essential. NCC certificate, these are the criteria, my lord. Nothing has been mentioned regarding Ratna or
So you,
problem.
yes,
And that happened, my lord. One more thing I would like to appraise this.
So he has basically challenged the advertisement, which was issued on 27th of December 2023. Today we are after 20 months he has come. He has challenged the rules which was there in 2003 rules as well as 2018 rules. So I have no objection regarding Lordship admitting this petition and issuing notice, but no order may be considered at this stage because an identical,
We'll just say any appointment will be.
yeah, that is the same order passed in an identical case in the month of March.
Okay, then we'll do that.
Yes.
And since
Has the
Next up-
selection been completed? No.
No, it is a final stage, Lordship. The interim order is identical, and interim order was passed.
Is that?
May I please?
Lordship, it is there, my lord. Page 129, Lordship.
Our affidavit is also ready in the other case. Both the case may come together.
Okay, right. Third, Mr. B. Shetty, Current Office for the petitioner who submits that rule 10 of the rule 10 and schedule 3, Roman 3, of the Assam secondary bracket, secondary education bracket, provincialized schools bracket, close service rules 2018, which treats Raveen/Ratna as equivalent to Bachelor of Arts, having Hindi as one of its subject or majors in Hindi, is unconstitutional and has to be set aside. He submits that in terms of the advertisement dated 27/3/2023 for appointment of graduate teachers, persons having the educational qualification of Raveen/Ratna are eligible to participate. Though for appointment to the post of upper primary school, they are not allowed to participate, correct? Upper
Okay.
primary school, they are allowed to
Yes,
participate.
no.
They are not allowed to participate. Issue notice. This honorable is 3 weeks.
Lordship.
Mr. D. Saiki, Learned Advocate General, submits that a similar matter is pending in this court, which is WPC 1392 of 2020. Submits that affidavit has already been filed in the.
No, it is ready. We are ready.
That the affidavit is going to be filed in WPC 1392 of 2025. Which will decide the issue in this case of. Accordingly, list this matter along with WPC 1395 of 2020, 1392 of 2025. After 3 weeks. Any selection in the interim, no, it is also made clear that any selection made pursuant to the impugned advertisement dated 27/3/2023 for filling up the post of graduate teachers, bracket arts, science, Hindi, and Sanskrit of the different provincialized secondary schools under the directorate of. Sorry, out is only Hindi. Out is only Hindi, yeah. Cut that. Hindi. Of the different provincialized secondary schools under the directorate of secondary education, Assam, shall remain subject to the outcome of the written.
Okay, one more line in my submission that I am raising challenge to the maintainability on the ground of delay and laches.
Okay. One thing, the learned AG has submitted that the writ petition should be dismissed for delay and laches. Besides the writ petition not being maintained.
Highly obliged.
All right.
But in this PI, we have filed our affidavit, they have filed a reply. Again, they have, in the reply, they have brought some photographs showing that the road has not been constructed properly. But my instruction in the affidavit was that it is already complete, only furnishing is left out. So I,
Complete.
no,
No, madam.
but our affidavit says it is complete, but they have.
According
they
to
have-
them, my
they
lord.
have given some
Just a
photographs.
minute, Mr. Council, one at a time. Yes,
But we have filed an affidavit in the matter showing that the road, 3 roads in question, they are all construction.
no, not complete, not
2%,
complete. Page 144, you come
2% is the left.
to 144.
Logic.
Page 144. This is affidavit of, rejoinder affidavit filed by 1, 2, 4, and 5,
Yes, yes,
28 July.
yes, yes. two,
You come to page 144, that construction of road from Hazirat Tinali to
yes, yes,
Bazar.
yes, yes, my lord.
That is
Six-
only 90%.
That is 90%, my
So
lord.
it is not 100%.
2%, two roads, total 3 roads are there,
Correct.
total 3 roads,
Two roads are completed, one road is not completed.
not complete, not.
When is it going to be completed?
Well, that they have said that by 31st of this month, they will complete.
No, did they say that?
31st of July, they said.
31st of July.
Yes.
Then,
Well,
find out.
now they have filed another affidavit in the matter, bringing on record that some photographs that they show that the construction has not been done. And well, I have to take instruction in this.
Huh?
I have to take instruction on this, their affidavit in reply. They filed a reply on 11/8.
Okay, right. The matter pertains non-construction of 3 roads by the respondent. In terms of the rejoinder affidavit filed by the respondents number 1, 2, 4, and 5 on 28/7/2025. Out of the 3 roads that are to be constructed, 2 roads have been completed. However, only 90% has been completed in respect of the road from Hazirhat Tinali to Kopati Bazar, Bazer. Huh?
Yes,
Kopati will be Khopati. Good stuff.
paragraph 3, we kindly see.
However, the affidavit in reply filed by the petitioner on 11 August 2025 at para 4 states that the 2 completed roads have not been completed as per specification. Further, in respect of the 3rd road, where the state respondents have taken a stand that 90% of the work has been completed. The petitioners have taken a stand that only earthwork filling has been done on the steps. Mr. Srinath Leonard, counsel for the state government, submits that he would like to obtain instructions with regard to the above. This is the matter on,
Lordship, give us 3 weeks time.
give it it.
Lordship.
Thanks for person. With 74 eyes and legs, matter will be passed over for time being.
What is to be done here?
My lords,
It's as per the rules.
no, my lords, there are 2 limbs of the submission. One is that the advertisement, now the advertised qualifications are themselves violative of the rules. And therefore, that is one part of it. There is also an additional challenge to the rules, the qualifications prescribed under the rules on the ground that they are violative of and they ought to be in consonance with what was prescribed by the central government in its notification. Those are the 2 submissions. If my lords may kindly have the advertisement.
Yes.
Yes, Lordship, we have filed our affidavit. In fact, this matter is covered by the judgment passed by the Honorable Patna High Court, my lord. I have annexed my affidavit also in the judgment.
Whereas my submission is that some of the arguments which we are raising here were not considered by the Patna High Court, and therefore that view is liable to be deferred by this honorable court. That is the submission. I've also filed a replication.
High Court judgment.
Please, my lords.
Lordship, that Lordship will find at my affidavit, start from page number, my lord. So from page number, let us say 305, and relevant paragraph is Lordship is page number 317.
Finish.
My lords,
My affidavit, my lord. 370, my lord. Lordship, may I read, my lord? Lordship, I got it. Having heard the learned counsel, may I read, my lord?
Yes.
Having heard learned counsel for the parties, this court of his view that contention of petitioners that in the notification issued by the central government, mandatory qualification for appointment in the transport department is diploma degree in automobile engineering is misconceived. Central government has issued notification prescribing minimum qualification as diploma degree in automobile engineering only for the post of motor vehicle inspector, which is technical in nature. In the same notification, it has been clarified that this qualification does not cover non-technical posts under transport department. Earlier person appointed as motor vehicle inspector in the Bihar State Transport Technical Cadre Rules 2003 had no promotional avenue, but after framing of Bihar such and such rules 2020, provision has been made for promotion of motor vehicle inspector on gazette post of additional district transport officer, joint transport commissioner, additional transport commissioner. Nature of the post, whether it is technical or non-technical, and qualification prescribed for appointment on such post in the transport department lies exclusively within the domain of executive. This resolution by the committee sent to the government is advisory in nature, and it is for the state to take final decision on the basis of such recommendation, and as such recommendation do not confer any enforceable right in favor of the petitioner. There is no merit in this petition, is accordingly dismissed, my lord. Here is also, my lord, the enforcement inspector is the non-technical post, my lord. MVI is a technical post. Lordship may kindly have a look.
No, let me hear let us hear the please.
please, my lords.
So now, what are you? You are holding what post?
My lords, I am a candidate. I'm looking to get into service. So I'm challenging the qualifications. My grievance
yeah,
is that this is,
You are not in service.
Nothing, sir.
no, not in service. I'm challenging the rule and the advertisement both on the ground that this is undue enlargement of the zone of consideration. This ought to be restricted to the 2 technical qualifications which are there under the rules.
You have. Where's your right? You're not in service.
No, my lords, not at this point. I'm a candidate.
And you want to take,
Yes.
you want to take part in the selection process.
Yes, my lords.
Post.
My lords, enforcement inspector
Enforcement inspector.
in
In
the
fact-
transport department.
Inspect in the transport department. Let us see the rule.
Rules, Lordship will find it page 84 of the
Just-
petition,
Page 84.
my lord. Regarding the qualification of.
My lords, may
enforcement
first see
inspector.
the advertisement, then the rules.
No, let me see the rule.
Please, my lords.
Page 84.
Straight away,
Yes, sir.
I find that you are on a sticky wicket. Page 84.
Lordship, I got it. Enforcement
Serial number
inspector.
3, enforcement inspector.
A degree in art, science or commerce was recognized by the government of Assam with 3 years. Recognized. So, this is the rule.
Yes.
Yes, my lords.
So you don't have this.
No, I
He
have
don't
this.
have that degree portion. He wants only the mechanical engineering.
No, I have the last part. 3-year HSSLC with 3 years diploma in automobile or mechanical engineering from recognized institution of Government of Assam, Government of India, and also by AICT. So I have this. What I don't have is the degree in art, science, or commerce. My principal
No,
grievance-
degree in art, where does it say the degree in art science? Okay.
I say,
Okay,
or.
okay,
So the first part.
this a degree in art, science or commerce of recognized.
Or.
This you don't have. But you have HSS.
Yes,
No.
it's also eligible. It's
I am
the
eligible.
date of my affidavit.
My grievance is that this is undue enlargement of the zone of consideration. This violates my rights. No, my lords, then my lords may permit me to cite a judgment.
Yes, please give me all the judgments.
So far is advertisement person as per advertisement, my lord, they already selection is made and ineligible declared.
And
Yes, my lord.
the
Yes, yes.
person who has been selected is.
They will be appointed soon.
They are going to be appointed by the department, but so far as APSC is concerned, my lord, that the result was declared on, my lord.
Where is the advertisement? Let us go to the advertisement. Before lunch.
See, my lord.
Huh?
Page 53.
Okay.
Department to the central government rules.
Yes, my lords, the central government has given a notice.
Yeah, it's repugnant to the central government rule.
Is it something like that?
My lords, my submission is that it is violative of Article 14 because it is contrary to the central government notification. Also, the Supreme Court Committee on Road Safety, which has gone into this issue, all of that material is on record. State after state has amended their qualification in sync with the central government, as also the Supreme Court Committee on Road Safety.
Okay, so it is.
There are interim orders also.
That it is repugnant with the central government rule.
No, my lords, not per se repugnant, but it is contrary to that. Yes.
So,
Please, my lords. So, my lords may have Annexure 6, page 85, which is the next page to the rules. Page 85, this is the notification of 8th of March 2019 of the central government. I'll read this. In exercise of the powers conferred by subsection 4 of section 213 of the Motor Vehicles Act 1988, the central government hereby makes the following amendments in the notification of the Government of India in the Ministry of Road Transport and Highways, published in the Official Gazette, YD SO 443E, dated the 12th June 1989, namely, in the said notification, under the heading qualification for serial numbers 1 to 4 and the entries relating thereto, the following serial numbers and entries shall respectively be substituted, namely, 1. 10th standard pass from any recognized board, and 2. A diploma in automobile engineering 3-year course or a diploma in mechanical engineering 3-year course awarded by any institution recognized by the central government or the state government, and 3. Holding a driving license authorizing to drive motorcycle with gear and light motor vehicles. So the central government is very clear. There is no
where is this notification? Where is this notification?
of the 12th of June 1989, my lords.
Yes.
Yes, that's also on record. That's page 98. That's part of Annexure 8. It's page 98. 98 it starts. The relevant part is on 99 in the middle. Well, it's in the middle. So it is in exercise of the powers conferred by subsection 4 of section 213 of the Motor Vehicles Act 1988, the central government hereby prescribes that the minimum qualifications for the class of officers consisting of the category of Inspector of Motor Vehicles or Assistant Inspector of Motor Vehicles, by whatever names called, shall be as under. Now the qualifications are minimum general educational qualification of a pass in 10th standard and a diploma in automobile engineering 3 years course or a diploma in mechanical engineering awarded by the State Board of Technical Education 3-year course, and working experience of at least 1 year in a reputed automobile workshop which undertakes repairs of both light motor vehicles, heavy goods vehicles, and heavy passenger motor vehicles fitted with petrol and diesel engine, and must hold a driving license authorizing him to drive motorcycle, heavy goods vehicles, and heavy passenger motor vehicles. Now, my lords, I stop here. This notification of 1989 as well as the subsequent 2019 notifications are very clear that there are only technical qualifications which are to be prescribed for such posts.
But this is for MVI.
My lords, no. My argument will be this will not exclusively be for MVI, because this very notification says, if my lords may see, minimum qualifications for the class of officers consisting of the category of Inspector of Motor Vehicles. So even the post of enforcement inspector is not very different from that class of officers and the category of Inspector of Motor Vehicles. The nomenclature is not relevant because each of the 28 states and 6 union territories.
There is no bar for the states to add some more qualification.
My lords, no, because my respectful submission will be.
You mean, huh?
My lords, my very respectful submission will be the Supreme.
See, they have said the minimum should be this. There's no bar for putting a
No,
higher.
but my lords, what they've done is they've not even gone higher. They've gone on to additional qualifications which have no nexus with whatever has been prescribed by the central government. So therefore, that's why it is open to challenge. My lords may kindly see the Supreme Court Committee on Road Safety, which has gone into this issue. It has made specific observations. Annexure 7, page 86, my lords.
Right?
Page 86.
Yes.
My lords, this is where the recommendations begin. The relevant is on bottom of page 89. So that's serial number 3, page 89 bottom.
Yes.
Technical qualification of transport officers and states UTs. So the committee has observed, the committee pointed out that section 2134 of MV Act 1988 requires the central government to prescribe technical qualification of the officers posted in the motor vehicle department of the states. The MORTH stated that they have already prescribed the technical qualification at lower management level, which is MV inspectors. Diploma is the minimum qualification for them. At middle management level, there is no direct entry, and therefore there is no direct requirement for prescribing technical qualification for them. They also stated that the Central Institute of Road Transport, Pune, imparts training to the state transport officers from time to time. The committee said it's important that officers at the middle management level, like ARTOs and RTOs, should have technical qualifications, and the approach suggested by the MORTH will take a long time to make this happen. Now, therefore, they've held two things. One, that the department is inherently and fundamentally a technical department, and that technical qualifications should be across the board, not just at lower middle management, but even at higher middle management. So therefore, once this recommendation is there, based on this, the Supreme Court, the central government has issued a draft notification also, 21st of July 2023, page 97, Annexure 8.
Yes.
My lords, I'll read from para 2. This is dated the 21st of July 2023. Accordingly, this Ministry YD SO 443E dated 12/6/1989 that we just read, and subsequently SO 1215E dated 8/3/2019 prescribe the minimum qualifications for lower management positions of MVDs, that is class of officers consisting of the category of Inspector of Motor Vehicles or Assistant Inspector of Motor Vehicles. 3. The staffing norms of motor vehicles departments have been examined by the Supreme Court Committee on Road Safety. In this regard, the relevant extract of SCC ORS observations YD meeting dated 12/7/2019, copy enclosed as Annexure 1, are reproduced below. The committee said that it is important that officers at the middle management level like ARTOs and RTOs should have technical qualifications. 4. In view of the above, the central government is proposing to prescribe the minimum technical qualification for direct recruitment of middle management of MVDs, that is RTOs, assistant RTOs, DTO, in addition to the lower management position. Few modifications in the minimum qualifications for lower management levels are also being proposed. So even the central government is echoing the same stand, is in furtherance of the Supreme Court Committee on Road Safety. Now, my lords may have state after state, they're implementing this. I'll just take my lords through one example. I've given references of at least 7 to 8 in my petition. My lords may straight away have the 2021, which is Kerala, Annexure 10, page 107.
Yes.
Please, my lords. Now, this is the notification Government of Kerala dated 16th February 2022, page 108, serial number 2, amendment of the rules. In the special rules for the Kerala Transport Service 1981, in Rule 4, after sub-rule C, the following sub-rules shall be inserted, namely, D, no person shall be eligible for appointment by transfer to category 4 unless he possesses the qualifications specified below. 1. Pass in SSLC or its equivalent. 2. 1. A diploma in automobile engineering or mechanical engineering awarded by the State Board of Technical Education or any institute recognized by the central government or the state government. 2. Any qualification in either of the above disciplines declared as equivalent to the above diplomas by the central government or the state government. 3. Must hold a current valid driving license authorizing him to drive motorcycle, heavy goods vehicle, and heavy passenger motor vehicle. Now, why was all of this done? Why have they made their rules in sync with the central government and the Supreme Court committee? The answer is on the next page. There is an explanatory note, page 109. The explanatory note, page 109. The Departmental Promotion Committee hire for the Motor Vehicles Department met on 1/3/2011 has pointed out that the post of Joint Regional Transport Officer is purely technical one. Appointment of senior superintendents, ministerial staff to the post of Joint Regional Transport Officer will not serve the intended objective as they have no technical knowledge. It will adversely affect the functioning of the Motor Vehicle Department, especially in technical matters. Therefore, the committee suggested that the Motor Vehicle Department should consider creating a separate stream for promotion of senior superintendents to non-technical posts. And the 10th Pay Revision Committee also pointed out that the post of Joint Regional Transport Officer primarily requires technical knowledge, especially the mechanical side of vehicles. It is for such a post, 1/3 of the posts are reserved for senior superintendents who do not have any technical knowledge. The by-transfer appointment is ostensibly to open up promotion avenues to the senior superintendents, and it is not proper and suitable for the post. The basic qualification and experience of senior superintendents are not sufficient to perform the duties of Joint Regional Transport Officer. Also, there is no test or method to ascertain the suitability of the employee to the post. Now, my lords, the next para is the Supreme Court Committee that we've just read. The second para on page 110. In Kerala, Assistant Regional Transport Officers, ARTOs, is named as Joint Regional Transport Officers. One of the methods of appointment for the post of Joint Regional Transport Officer / Personal Assistance to Deputy Transport Commissioner / Assistant Secretary State Transport Authority is by transfer from Senior Superintendents of the Motor Vehicles Department under Kerala General Service. The special rules for the Kerala Transport Service do not specify the qualification for by transfer appointment from the post of Senior Superintendent to the post of Joint Regional Transport Officer, which is having completely different nature of duties and which demands technical knowledge. Hence, the entry of officers without technical knowledge to the post of Joint Regional Transport Officer through by transfer appointment and then to higher key posts by promotion is extremely detrimental to the functioning of the department and is against public interest. Even the subsequent two paras are to the same effect. So this is the explanatory note. The state has amended this in 2022. My lords, similarly, there are other 7 to 8 examples, but my lords, I'll take my lords to an interim order, or 2 to 3 interim orders. The first is one passed by the Rajasthan High Court. It's page 157. Annexure is 17.
Huh?
Annexure 17,
Page
157. This is an interim order. Learned Counsel for the petitioners submits that condition of eligibility prescribed by the advertisement dated 24/11/2021, inviting applications for appointment on the post of Motor Vehicle Sub-Inspector, being contrary to the eligibility prescribed by the central government for the same post, YD its notification dated 8/3/2019 is bad in law, in view of the provisions of sections 2134 and 215C2B of the Motor Vehicles Act 1988. He submits that the petitioners are eligible for appointment qua the notification dated 8/3/2019. Now, my lords, and the last interim was granted to the candidates to participate in the selection process.
That's a different issue. That's a slightly different issue. Out here, they were not allowed.
So,
Out here, you are allowed.
no, yes, I am allowed, but my lords, the larger argument I have
Whether
participated.
persons
Yes.
or degree holders could participate. That is it.
Yes. So my submission is that the degree holders, because the central government has not
We'll
permitted.
have to see what is the job of an enforcement inspector.
Please, my lords. So detailed submissions I've made as to the functions which are being performed. So as per their own reply, they say essentially anybody who enforces the motor vehicles laws, which is the Motor Vehicles Act and the Central Motor Vehicles rules, performs the function of enforcement.
Does the enforcement inspector need to be a technical person?
Yes, my lords, that's my submission. They may argue to the contrary. My submission is this.
Because I think the Supreme Court
In,
explanation and the judgment that you relied upon
please, Manoj.
does not make a specific mention of enforcement inspector.
Manoj, because each post, no, there's even an interim order that I've attached. Insofar as the post of enforcement inspectors is concerned, that's Punjab and Haryana High Court. That's also on record. Manoj, my submission is the post of enforcement inspectors does not exist in most states. Because each state will have different posts, the central government cannot be expected to give the nomenclature or the Supreme Court committee of each post existing in every state. In most states, there is nothing called enforcement inspector. Those functions are being performed by motor vehicles inspectors or some other officials and vice versa. So therefore, because what my lords have to see is the functional test. So if they perform any technical functions, therefore, in terms of the notification dated 12th June 1989, automatically that post will become a technical post. So it is the test of functions. That has to be gone into. If my lords were to see my replication, I have annexed the judgment of S. Rajashekharan, 2014 Supreme Court, which basically talks about what enforcement is. My lords, that's page number 370, annexure 34, it starts.
Where?
My lords, in my replication to their affidavit of opposition.
Okay. It's not.
File हुआ हुआ है ना?
It's not in the file.
File.
When did you find?
कब फाइल हुई? नहीं फाइल कब हुआ? My friend informs me it's been filed, but the date is.
Been filed, but not on the record.
Yes, I have received copy.
Yes, so there is one thing.
Yes, my lord.
What is the role of this?
Yes,
enforcement inspector?
that lordship will find in my affidavit, I have the definition of the enforcement and MDI I have reproduced, page 301, my lord, of my affidavit. 301.
Yes,
Lordship, the paragraph 16, lordship, may I read my, lordship has got it? That we regard the segment so and so dependent back to submit that the scope of work carried out by the enforcement inspector is enumerated in the definition clause of Rule 2H of the Assam Motor Vehicle Rules 2003. Rule 2H and Rules 2K of the Assam Motor Vehicle Rules is reproduced here in the 2H. Enforcement inspector means the officer appointed as charged by the government the purpose of enforcing the provision of the motor vehicle laws to detect the violation of such laws. And 2K, motor vehicle inspector means an officer appointed as such by the government for the purpose of inspecting the motor vehicles mechanically and for the purpose of examining the proficiency of driver, detection of violation and enforcing the provision of motor vehicle laws, and includes any other person appointed and authorized by the government for the purpose aforesaid. And lordship, the rules for MDI, lordship, which is the minimum qualification that my lord will find it page 84 again, my lord, in the petition, my lord. We have motor
for the rules for
qualification from MDI,
for a
MVI,
MVI, motor
Yes.
vehicle inspector.
inspector. This is lordship will find it page 84 of the petition, my lord. Lordship will copy page 84.
Yes,
May I read now? Number
84.
84 of the petition of
Yes.
the qualification, serial number 2, motor vehicle inspector. SSLC with 3-year diploma in automobile or mechanical engineering from a recognized institution. So we have MVI and we have EI. So definition itself reflect what is the duty of an enforcement
So
inspector.
this is as per the Supreme Court.
Road safety notification, lordship, the Patna High Court had says that their notification issued by the MORF is advisory in nature, not mandatory. This is my case, my lord. Page 317, the judgment of the Patna High Court. Similar issues has been already decided. Page 317.
So this 8 March 2019 notification.
Yes,
So it, has been followed for motor vehicle.
MBI, for MBI. MVI is a technical post, Lordship, not the enforcement inspector. So degree is the qualification for enforcement inspector as well as the other engineering qualification also included. Eligible for participate in their selection process.
And this page 86 is the Supreme Court Committee on Road Safety
Yes, this is advisory in nature, not mandatory.
recommendation.
It is recommended, all recommendations are all for the MVI post, motor vehicle post. We have stated in our affidavit, my lord. Paragraph 14, in fact, the order of the other honorable high courts is also related to the,
No, the Inspector of Motor Vehicle.
yes, my lord.
Assistant Inspector. So it's
Yes.
not for enforcement. It's okay.
Yes, my lord.
My lords. My lords, two submissions. One, the Supreme Court Committee on Road Safety has not restricted any observation to the post of MVI. Very clearly, it says the central government is to prescribe technical qualification of the officers posted in the motor vehicles department. It is not restricted to only MVI.
Correct. So let them do it. But what it has clarified here is for the time being, the MVI, those should be they should have this minimum qualification.
As per their own definition, what my friend just read, the enforcement inspector is to enforce motor vehicles laws.
Correct.
That my friend read. Now, my lords, what are motor vehicles laws? What is enforcement? What uske copy dena judgment ki. The replication is not on record, my lord, somehow. Otherwise, the Rajshekharan judgment, 2014 Supreme Court says that what is enforcement? Enforcement has various aspects, such as ensuring. My lords, I'll just take out the relevant para 24 of this judgment.
Those aspects will be taken care of by the department at the relevant point of time.
No, but my lords,
Now
once.
they are actually, we are trying to include enforcement inspector within the definition of MVI.
My lords,
That's a slightly
the
different.
moment they vest technical
Where
functions
does
in
it
them.
say, where does the Supreme Court Committee talk about the enforcement inspector as being required to have this minimum
Well,
qualification? Doesn't it?
My lords, the Supreme Court Committee has said that one, the department is inherently technical and officers posted in the department should have technical
Yes,
qualifications.
sir, we have MVI.
The central government has said in 12/6/1989 that,
It is only a recommendation,
My lords,
advisory in nature.
but the central government is still binding because the central government prescribes the qualifications under
For
2134.
NVI, not for enforcement inspector.
No, my lords, may kindly see, it does not talk only about MVI because the legislature is very conscious when it uses those words. It says consist for the class of officers consisting of the category of assistant inspector of motor vehicles, etc., by whatever names called. So if their intention was to only restrict the post of MVI existed in every state, even back in 1989, they would have consciously restricted it to that post.
How do you know? You might be selected off. You might
No.
have been one of the.
Then my lords may ask the central government to come and clear the stand. If they say that it's only for MVI, I'll.
After hearing you all so much, why should we waste time?
In our affidavit was stated, Lordship, my kindly.
My lords may also then, my lords may give me an opportunity. My friend tells me the replication was filed on the 6th
No,
of May.
we heard you. You think that.
No.
Yes.
My lords,
Decide the
the
matter.
functions, because
If
the-
you want, you can, we're going to dispose it of. Either or, and probably it'll go against. Only thing is, if you want, you can withdraw with liberty being given to challenge. To make a challenge to those persons who are selected on the basis of their qualification of having a.
Already
Only on
resolved.
that ground.
then my lords may
Because-
just adjourn it for a few days. I'll get instructions as to the result.
No.
Because if I have not cleared the exam somehow, then I'll be out of the court in any case.
They're going to be out anyway. They don't have a cake and eat.
Then my lords may grant.
See, because you see, one thing is that you can always ask for your ranking, where you are. And supposing, how many posts are there to be filled?
26.
26.
27.
Now, out of 26, you might be among the 26 technical person who could have been appointed. but maybe 13 graduates are appointed.
Yes.
But depending upon your position, you can make a challenge to those persons, but not now.
Yes.
My lords, may pass over. I'll get instructions as to this matter.
No, sorry. You can go to the higher forum.
No,
We heard you.
because
We're not, we have heard you at
Say the citizens.
some length. Basically, we've made up our mind on.
then my lords may
So it depends
then
upon
my
you.
lords may permit us to withdraw
Ah.
with liberty.
Yes.
Then that by that time you might be able to better your case. Okay, right. Heard, Mr.
No, what's your name?
Bhavpreet Singh.
Huh?
Bhavpreet Singh.
Bhavpreet Singh. You're from where?
My lords, I'm from Chandigarh.
Okay, Bhavpreet Singh. Learned counsel for the petitioner who submits that he may be allowed to. Your wakalatnama is here?
Yes, my lords. Yes, yes, yes. It's there. Along with my friend, it's there.
Yes, also. I'm MD Amhawk.
Learned counsel for the petitioners who submits that he may be allowed to withdraw the writ petition. And with the liberty to file a fresh in the event of candidates having degree in arts, science or commerce of a university recognized by the government of Assam being appointed to the post of enforcement inspector under the transport department, government of Assam, pursuant to the advertisement dated
6th August 2024.
6th August 2020. Ms. D. Bora, hearing for the
MD Board of
MD Bora for
Transport Department 1 and 2.
submit as still, but no objection to this. Mr. T.J. Mahanta, learned senior counsel for the APAC, appearing for the response number 6, submits that the selection process has been completed and recommendation for appointments have been made for filling up the 26 posts, 27 posts of enforcement inspector. He submits that the appointment orders may be issued at any time by the state government. On considering the prayer of the petition party, the writ petition is dismissed with liberty being given as stated.
Replacement.
21/5/2025 passed by the court of the additional district and session judge bracket FTC-2, Tinsukia, convicting the appellant under section 302 IP in sections number 85 bracket CH of 2019. Should be settled. You should notice returnable. 4 weeks. Wait, no, let's say Miss A. Begum, additional PP, accept notice on the other side. Admit the appeal, call for the clear. This is the matter. After 4 weeks. There's no requirement of issuing any notice to the respondent.
May I please, your lords?
Can you have a look the last order of the summer before? No copy has been served to us till today.
I will not say, one day time, today I will be children. I'm sorry, lords. Yeah.
Correct. Despite the last order, no brief No, the copy of the appeal has not been submitted, has not been furnished by Mr. A. Deka, learned counsel of the appellant, to Ms. M. D. Bora, learned counsel for the transport department,
WMD department.
WMD.
Today,
As per
They
the
have submitted that he will furnish a copy of the appeal today.
Lordship.
This is the matter.
Any day, Lord.
When? Next week.
As per laws, you can.
You will date next week. Second one.
Lordship.
Obliged.
Wait a dear. Develop.
Miss
S Nazneen.
S.
S Nazneen, Lordship.
Nazneen. Learned counsel to the appellant, submit that the imprisonment judgment in order dated 4/7/25, by which the learned petition judge Bongaigaon had convicted the appellant under section 302 IPC in Sessions case number 12 bracket M of 2019. Should be set. Admit the appeal, call for the TCR. Ms. A. Begum accepts notice on behalf of the. This is the matter of the court.
Yes.
I right? Ms. A. Begum additional 104 weeks. Right. It's objection to the application under section 430 BNS.
5 weeks, sir.
5 weeks. Then the other thing also make it 5 weeks. In the issue notice. Okay.
Wait, please, Your Lordship. Two appellants are here, Lordship, against the conviction. The one is convicted, Yarul is convicted under section 6 of POCSO Act, Lordship. And Akid Hasina, she is convicted under section 96 BNS, sorry, Lordship.
Right. Right, Mr. S.K. Potter. Learned counsel for the appellant who submit that by judgment dated 18/6/2025 passed by the additional session judge cum special judge Pokto Moriga in POCSO case number 132 of 2025, arising out of Mikir Bhetta PS case number 119 of 2024. The appellant Diarul Islam
Yes, Lord.
has been convicted under section 6 of the POCSO Act and under section 87 BNS. Costa. The co-accused, the co-appellant Hasina Begum, alias Khatun, is convicted under section 96 BNS. Costa. Issue notice, admit the appeal, call for the LCR. Issue notice returnable in 4 weeks. Ms. A. Begum accept notice on behalf of the state. Appellant shall take steps for service of notice upon the respondent. Number 2, bracket informant. By serving a soft copy of the appeal petition to the registry, to the PP's office, who shall thereafter have the same served on the respondent number 2 to the OC of the concerned police station. This is the matter after 4 weeks. Now, there are two applications.
Two applications, Lordship.
You withdraw.
For life punishment, so notice will go to people, Lordship.
This is under,
866,
this is under which section?
430, Lordship.
Please look.
It is a, sorry, Lordship, typo error, Lordship. And maybe it is 430, Lordship, it should be.
You see, you have to change the entire application for one thing.
That's it.
Nowhere have you asked for suspending the sentence. Unless you ask for suspending the sentence, there's no question of bail. You withdraw this
I
and
made
file a
mistake. I made
You make an application under 430
Your Lordship, yes.
asking for suspension of the sentence and resultant bail.
Yes.
Okay, right. Mr. S, huh? Item 14, both the IAs, huh? Mr. S.K. Pradhan, Learned Counsel for the
I beg your
applicant submits that he may be allowed to withdraw the application with liberty to file a corrected application. The pair of Miss A. Begum, additional PP present. The pair of the applicant is allowed. Application is dismissed as withdrawn with liberty as written.
Yeah, please. Is of 14 losses.
Right, Mr.
A Rahman.
A. Rahman, Learned Counsel for the appellant who submits that the special judge Poxo, Aman Nalwari, convicted the appellant under section 6 of the Poxo Act in special bracket Poxo case number 44 of 2024, arising out of Mukalmua PS case number 10 of 2024. Admit the appeal, call for the TCR, issue notice, returnable in 4 weeks. They become additional PP except for 5 weeks. 5 weeks, huh? Miss they become additional PP except notice on behalf of the state. Appellant to take steps for service of notice on the respondent number 2 by submitting a soft copy of the appeal petition to the office of the PP, who shall thereafter have the same served on the respondent number 2 to the OC of the concerned PP. This is a matter of the court. I, Ms. A. Begum, additional PP is granted 5 weeks time to file objection to the application under section 430 BNS.
High levels.
Item 16.
May I please, Your Lordship? This is an appeal by the state, my lord, against the judgment and order passed by the Honorable Single Judge. Factual matrix in brief is that, my lord, way back in the year 1976, certain part and parcels of land, certain plots of land owned, alleged to be owned by the predecessor in interest of the writ petitioners were acquired. Having found
By whom?
acquired by the my lord district collector under the provisions of 1956 Sealing Act, meaning thereby, my lord, that they had, my lord, they were in occupation and ownership of land beyond the permissible, my lord, limit, which is prescribed in the 1956 Act. Now, 1956 Act prescribes for maximum permissible limit of 50 bighas of land per person, and per person definition includes, my lord, per family. Be that as it may, my lord, those proceedings were drawn up. They never objected to it, my lord. And much water has flown down in between. And in the year 2012, they laid a writ petition, my lord. They laid a writ petition that, my lord, they are entitled to challenge those, my lord, proceedings, sealing proceedings. Now, my lord, some orders were passed. Eventually, my lord, in the year 2020, they had filed a writ petition. Now, claiming that, my lord, these sealing proceedings, which were drawn way back in the year 1976, my lord, suffers from technical defects. And on that count alone, my lord, the Honorable Single Judge has allowed the writ petition. Now, my lord, the difficulty here is.
When did it culminate? Sealing proceedings?
It culminated way back in the year 76 itself. 76. Now, those records were also not found. And at that point of time, in the year 1976, the district of Kamrup was one single district. It was not bifurcated. Now the matter pertains to my lord Kamrup Rural District. Now, when these writ proceedings were laid before this honorable court, during the pendency of the writ proceedings, the district collector, that means my lord, that deputy commissioner had filed successive affidavits wherein we have taken a stand, my lord, that since it is a old pending matter, lot many records are not traceable. That is one aspect of the matter. Second aspect of the matter is most important, my lord. They say, my lord, that the sealing proceedings were drawn under sealing case number 372 of 76 and 384 of 76. We say that those no, my lord, the lands were acquired under those two sealing cases. In fact, there is some other sealing case, 375 of 76. So there was a dispute. Now, after having acquired the land in the year 1976, those lands, my lord, the surplus lands have been settled with several persons, various persons, including institutions, my lord. And their name has,
When was that?
my lord, it was after
Settled when, which year?
settled, my lord, from 1984 onwards. These are part of the record. Now, my lord, we have also given a list of persons whom the lands have been settled.
So those persons, are they part of the?
No, they were not implemented. Even after filing of the, my lord, affidavit, my lord, they ought to have implemented those persons. Now, my lord, the consequence of the judgment and order put in appeal, which is put to challenge hearing, would be, if we accept it, my lord, we have to change the revenue record. There has to be correction and deletion of those names. Now, if that is done, my lord, then those rights of those persons will be affected. That is one. Number two, my lord, most importantly, there is not a single finding, my lord, with all respect, that they were in occupation of the plots of land. Had they been in continuous occupation of those plots of land, matter would have been different. So, my lord, since on record, it is, my lord, conclusively proved that some other persons have been settled and they came into occupation of those lands. Ipso facto, my lord, brings the inference, my lord, that they were not in occupation. So this is how, my lord, the matter stands, my lord. So at this stage, my lord, I humbly pray, my lord, that let this appeal be admitted, my lord. Lordship will examine, because a lot of factual matrix is involved here, my lord.
Yes.
In fact, my lord, the Commissioner Secretary Revenue has already admitted that the entire process was dehors the Act. Now that the Act contemplates that I should be given a choice of retention. That was never given to me. The Act contemplates that the final statement, because ultimately it becomes Sarkari only when the final statement is published. There is no record of the final statement. There's an admission by the Commissioner Secretary that final statement was never in fact published. Insofar as the rights of the other
So
partner.
you don't know which part of the plot should be yours and which.
Exactly. In fact, there's a order which says I had in fact exercised my right of retention by saying that patta number 9, that's the subject patta, should be retained in my name. That was totally ignored. In fact, the final statement does not even indicate what are the parcels.
Why have you come so late in the day?
Because it was never published.
No, but at the end of the day, it appears that these plots of land were distributed, allotted.
That also, there's absolutely nothing on record to suggest that. In fact, if your lordship takes up 326 for a moment, page 326, that's part of the order, my lord. Here, my lord. In fact, the ADC says that there was no allotment, it's still in my possession. During the course of the writ proceeding.
So the first issue is,
My lord.
in whose possession is the land in?
My lord, it is in our possession. We've made a categorical statement. They have, in fact, the ADC has himself endorsed that yes, there has been no allotment as such. They're still in possession, my lord. All said and done, ultimately, if they want to acquire it, it has to be done as per the Act. Now, nothing, even the final statement is not there. So how can they say that it's become Sarkari out of the blue? Now, 326, my lord, the Commissioner Secretary has observed that there is no even record of publication of these statements. Number two, there was no formal handover of possession. Number three, there was no allotment or not even a single penny has been paid as compensation. So when the single bench realized that it's totally dehors the law, I mean the Act. So therefore, ultimately to take away my right, they ought to have shown something. In fact, the final statement is missing. It's not signed, it's not published as it is mandated.
So that That we have categorically stated because
No, it's not a question of stating. You can say anything. The question is where the document supporting your statement.
those, my lord, we have got, my lord, on affidavit, we have stated, my lord, that those documents are not available because it pertains to way back in the year 1976 and after by.
Mr. Council, one thing,
My lord.
you are allotting land.
No,
You have allotted that land according to you to somebody.
my lord.
Now that allottee, we surely have some document.
Yes.
You see, you all have, I think every one of you all have got some land somewhere. Most of you all anyway. Your family will be having. You can't say that "Hey, since this land document is 50 years old, I'm throwing it away. Will you do that? A common person will not do it, let alone the government.
Absolutely. Now, therefore,
Another
now-
thing Another thing I'd like to point out, the state need not espouse the cause of those persons, my lord, because those persons had filed an impleadment. And they took liberty and withdrew the IA and said, we'll pursue our remedies elsewhere. In fact,
So have they pursued it elsewhere?
they haven't so far.
now the fact, my lord, that the records were corrected, rightly, wrongly, records were corrected. We have filed an affidavit during the writ proceedings. Lordship will find it at page 244. Those materials are not controverted. Those materials are not controverted. We have annexed the record of right, the Jamabandi. It's a part of the record during the writ proceedings. There is an additional affidavit, my lord. The affidavit.
Allotment records are there.
Yeah, absolutely. During the writ proceedings, we have laid it before the honorable single judge, my lord, along with a report of the cycle officer.
You all laid it before the
Yes,
citizen.
my lord, page number 244. Kindly see, my lord. Page number 244 of the paper book, my lord. Memo of it.
And the land that has been now retained by the writ petitioner as his own, the area that is allowed to be retained. Can we have a record of that?
Nothing has been retained in my name as on date.
Nothing is written in their name.
Why? They lose everything.
No, because they do not have any possession, my lord. Lordship will kindly perceive a situation, my lord. This is a plot of land. I say this is my land. He is the government. He can take away, my lord. He can, by following due process of law. But I have to be vigilant. I have to be vigilant.
Now, where is your
this ex-
land right? You don't
I
have
say, my lord, there were three.
land document. You don't have any.
I have.
Because you don't have.
No, my lord, what has happened here is I had three patkas, my lord. Number 2, number 3, and number 9. Way back in 1976, my predecessor had said that I want to retain 9. Now that was not given to me as it appears from the draft statements. 9 was made sarkari. Then ultimately 2, 3 have already gone. 9, which I had chosen to retain, was also made sarkari. Now, if they want to make it sarkari, ultimately they'll have to do it as per the process of envisaged. And in fact, the Commissioner Secretary, the ADC, has at page 146, my lord, they had made a clear statement.
Anyway, let us just admit this and let us decide that.
Not only anxiety is, my lord, if the order is stayed. Now, those, if they say this being in a lot.
No stay for the time.
No, if it is not stayed, why making this submission? If it is not stayed, my lord, there will be a catastrophic, my lord,
We'll say that
consequences out there, my lord, on site. Because once the records are now corrected, now we'll have to, my lord, turn the clock back. It is something turning the clock back. So therefore, the names of those persons, institutions, by a flux of time, who came into occupation of those lands, my lord, and whose name has been recorded in the record of right, those have to be now struck off, and their names has to be restored. Once this is done, my lord, then what will happen, my lord? There will be a catastrophic consequence, my lord, in that area.
it appears that you have got no document.
No, we say, my lord, that it was done under.
See your document.
Lordship will kindly come to page 244, my lord. Page 2.
We saw those allotment documents.
Yes, my lord.
Rightfully allotted.
Yes. Lordship will kindly see. Absolutely, my lord. On affidavit, my lord, we have got it on record, my lord, before during the writ proceedings. Page number 244. This is the affidavit. This is the affidavit, my lord. Page number 244. This is the affidavit. And Lordship will kindly come to, my lord, page 250. Kindly see, my lord.
Yes.
250. It is a report. It is a report of the circle officer.
250.
250. 250 is a part of this affidavit, my lord. $250 is the report. The circle officer is the primary
This is
officer.
only a letter. Where are the documents?
The documents thereafter, Lordship will kindly see, my lord, from page 254 onwards. 254, we have given the translated copies. 254 onwards. And then, my lord, 266. 266. Page number 266.
The one paragraph I'll place from 146, my lord. This is the version of the ADC.
Huh?
One particular statement, the version of the ADC at page 146, my lord. Their own officers have said.
Anyway, we cannot decide this matter now. It's quite a voluminous thing. I mean, it'll take some time.
Only I am not espousing the cause of those private individuals or the institutions for that matter who came into occupation. But my lord, it's a pure issue of law. It has been corrected.
No, look, he has got land beyond the land ceiling, correct?
Absolutely, that's what.
Now, what remains with him?
Nothing.
Nothing. That can never be, my lord.
Okay.
No,
In fact,
Suppose how many bigas can a person have?
50 bigas.
50 bigas.
Total 50
So
bigas.
he had land beyond 50 bigas.
He had land beyond 50
So
bigas.
at the end of the day, you can take away only
What is
The-
let's say.
50 bigas.
Absolutely.
So where is that 50 bigas that he is supposed to have?
No, he is still having, my lord, in other areas.
Lord, in fact, that was the most pertinent finding of the single judge. For the property to vest on the state, there has to be a final statement indicating the retention and the surplus. Now, that final statement itself is not there, that main document.
Yes. So therefore,
And
there
they
were.
say it's lost.
Yes,
lost.
well, I take it. There were 3 cases, land selling cases. Well, those are independent proceedings. 372 of 76, 375 of 76, and 384 of 76. All along, they had hesitated, my lord, that the authorities have not followed the procedure laid down for, my lord, acquiring the surplus land in respect of, my lord, selling case number 375 and, my lord, 384. We say 375 and 384 are pertains to some different plots of land. It is not connected.
Okay.
It is related to, my lord, 372 of 276.
So
And-
even if it is 372,
372, they do not come. Their name, my lord, doesn't figure in 372. Some other person's name figure in 372. That is also one aspect.
then where do they come in? They do not come in anyway, but you take their land.
No, lordship, we have taken the land. We have categorically stated that we have taken the land in terms of, my lord, 372. Now they say, my lord, that
Their names are not there. How did you take away their land without their names being there?
therefore, my lord, with all
Let's not take advantage of everything.
No, I am not taking advantage.
You're having a cake, eating it too. Even the box where the cake was brought, you're eating that also.
They being
Nothing
the
left.
no, my lord, they being the dominus liti in the
Huh?
during the they being the dominus liti during the writ proceedings, they ought to have laid, my lord, conclusive materials before the honorable single
And
judge.
it cannot be decided now.
That's
I
what-
think I'll have to see the entire thing. But prima facie, it doesn't appear
No,
that.
I
they've got
also
a good
admit,
case.
my lord, that we have lost the records because I cannot travel beyond what is
Very-
the records.
Very unusual. Land document, if it is 100-year-old document also, you will preserve it somehow.
Yes.
Because you've got to prove your ownership over the land.
Yes. But here
Government
in,
also will do the same.
here in this case, my lord, we had made a categorical statement. Yeah, on affidavit, that those records are not present.
The excess land,
Hmm.
are you bound to pay any compensation to them for taking away the excess land?
Yes, the procedure is laid down.
So is there any record of you depositing some money or did you give it in cash?
No, my lord, those things are not there. my lord.
Nothing is there.
Nothing. That I'll have to admit, my lord. I have to be fair, my lord. I have to be fair.
In fact,
You are fair here because we have got nowhere to run or hide.
No, my
But
lord.
like I said, everything eaten up. Cake eaten up, birthday candles eaten up, the box where the cake came was also eaten up.
My lord,
Nothing.
No, I taste it, my lord, I taste it.
No, he's
That
in the.
lord, the single judge has given them the liberty to redo the exercise if they need so already. Under the act. Let them issue proper notifications and then assess how much is the surplus.
Lordship will examine at the end of the day, if it is found that nothing survives, my lord, Lordship will.
Why should we give stay?
No, my lord, if it is not stayed, my lord, then the records will have to be corrected. And once the records will corrected, my lord, there will be law and order situation there. Because,
But prima facie, you've got no case also.
no, my lord, Lordship will kindly see, assuming for the time being, that these plots of lands have been most illegally, my lord, most illegally settled with those persons. They knew about it, my lord. They ought to have challenged. If those are their lands, they have not made any challenge.
Yeah,
At the end of the day, my lord, it is only
we'll just stay for the time.
principle is my lord,
Lord, in
factum
that
of
case,
knowledge.
can I pay for a fixed hearing?
Yes. Yes. Or we fix a short date without stay.
Yeah. Nothing's gonna happen.
You bring all the records.
Records, my lord, we will.
Naturally. Your aim should not be to keep
No, no,
it
no.
and then keep it pending in the back burner, huh?
I would be the last person to do that. But everything is, my lord, I will be, my lord, agitating on the strength of whatever is there in the paper.
Then you came very late in the day.
What has happened
that is
was,
not
our
respectful.
case was very simple. 2009 till 2009, we are in possession. Suddenly we find in the records it's become Sarkari. Then we filed a series of RTI. It is they who disclosed 371, 372, 385. We had absolutely no idea because no notices were served. And that's the categorical finding of even of
Where do you live?
My lord, I stay elsewhere. You know. This is ultimately agricultural land. Some tenants were also cultivating. You know, that's how it is. My lord, if your lordship is hearing the matter in a short duration, my lord, perhaps there's no need for a stay. We are not pressing for a mutation as on date, my lord. In fact, a series of negotiations was also held because single judge thought that it would sort of unsettle the entire thing. The state had called us for.
Actually, this has to be settled. Whether it can be fully decided here, I don't know.
So therefore,
My lord, some endeavors were made during the writ proceedings, my lord, but it culminated into, my lord, no settlement.
in fact, my lord, my instruction subject to what my friend says, my lord, GMDA had shown some interest in it so as to acquire it formally from us and to set up a market there. Those discussions are underway, my lord. So therefore, if I may pray, my lord, let the matter be posted for hearing in the course of time if we can mediate, settle or whatever. But if a stay operates, my lord, then again.
I am not.
Can we send it for mediation?
Perhaps not, my lord, at this stage. Because
Several attempts were made.
Attempts were made. Attempts were made during the writ proceedings, my lord, before the honorable single judge. And whatever has been submitted right now, my lord, that the GMDA now like to acquire it, my lord, I am not privy to it, my lord.
Okay, right.
Privy to.
Then it comes. This comes for the first time.
First time, my lord.
Then it passes for the appellant state who submit that the judgment and order dated 14/11/20 passed by the learned single judge in WPC 5616 of 2020. Should be settled. The learned single judge by the impugned judgment and order had held that no rights to transfer to the state on the basis of the sealing case number 384/1974, sealing case number 375 of 1976, and sealing case number 372 of 1976. In respect of the lands of the petitioners upon which the state, upon lands of the petition, by virtue of section 7(4) of the
This will be made an Assam Fixation of Land Holding Ceiling Act.
Sam fixation of land,
Ceiling on land holdings.
Ceiling on land holding,
land holding act.
1956, my lord.
56.
My lord.
It also held that any right on the basis of the above proceeding created upon any other person by the state,
Yes.
would be a nullity in the eyes of law. Next part. The learned counsel for the writ appellant submit that the sealing cases had been disposed of in the year
1976.
in the year 1976, and the lands of the petitioners relates to sealing case number
My lord, ceiling case number 372 of 1976.
372 of 1976, though the names of the petitioners are not in sealing case number 372 of 1976. Correct?
My lord, so far as my lord, the nomenclature of land is concerned. Nomenclature of
Or so far as the nomenclature of land is
land is concerned. We go by the land, my lord.
no, so far as the nomenclature of the land.
Absolutely.
Next. The stand of the landowners, on the other hand, is that there has been no fixed finding made by the state respondent as to the land that is to be settled, that is to be taken away by the over and above the land ceiling of 50 bighas. Further, no compensation for the acquired land had been given by the state respondent to the petitioner. Correct? Issue notice returnable in 1 week. Mr. Yes,
BD
BD, accept notice on behalf of,
He is on caveat, my lord.
I was on caveat. my lord.
He is on caveat.
oh, he's a caveat.
For all the respondents.
Appears on behalf of
All the respondents barring 4 and 5. They've been subsequent.
all the respondents barring respondents number 4 and 5.
4 and 5. No, 4 and
Right.
5. 4 and 5 in the meantime, they have expired. So their legal years have been substituted. And accordingly, my lord, the cause title has been amended.
So, where you have to issue notice to 4 and 5.
They had appeared, my lord. They had appeared for some other council.
Okay, this is the second time, first time he says.
During delay condonation.
No, my lord, during delay condonation, my lord. It is come for the first time for admission, my lord.
Okay, okay.
There was a delay of 62 days, my lord. It's a condon.
As respondents number 4 and 5. This is the respondent. Just show me this thing. The IA for condemnation or delay?
Yes, my lord.
It has been condoned.
Yes, there has been condon. My lord, there was a delay of 62 and odd
Were
days, my
they
lord.
there? Were they there?
They had filed an application before this honorable court for substitution, my lord. Bringing on record, my lord, that in the meantime, my lord, this R4 and R5 has expired. There is an order, my lord.
In which IA?
IA, my lord.
485, should be 480.
485, yes. IA 4.
This is for delay of
Delay.
61 days.
61 days. Well, lordship will kindly see my, well, yes, there is another IA, my lord, IA 1500. I'm so sorry, my lord.
Huh?
1500 disposal.
One,
IA 1500.
I don't have it.
I have a copy of the order, my lordship may kindly. 1500.
Okay, right. As respondent number 4 and 5 had filed IA Civil 1500 of 2025. In this appeal, notice is served, is deemed to be served on the respondent number 4 and 5. According to notice is served upon all the respondents. Notice being served upon all the. Is served upon all the. This is the matter on,
Meaning dated after, it's the third week of September, third or fourth.
no, on third week. This is the matter on, give it,
23rd, if it's not.
23rd.
23rd, some document, my lord.
And you said returnable in four weeks. Why should, I thought you wanted to hear it next week or something.
I'll be.
Let it be returnable in 4 weeks, my lord.
Returnable in 4 weeks. This is the matter on when?
My lord, 23rd of September is a Tuesday, my lord.
23rd September, as per the consent of the party. On the said date, all the records should be produced by the.
Absolutely. In fact, my lord, during the read proceedings, we have brought trunk load of records, my lord. But the relevant parts are not,
Relevant ones.
relevance are not there.
All the relevant records, otherwise we don't want.
But I have an IA, my lord, for staying, my lord, kindly, my lord, if that can be. Subject to lordship's discretion, my lord. Otherwise, if he undertakes, my lord, that he is not going to, my lord, pursue in terms of the honorable single judge, my lord, I may not press the IA. It's between him and me, my lord.
But his persons are very convenient. But I'd say, well, it's still September, well, nothing major is gonna happen.
I don't know, something could happen. Right, so it probably, father stay on the. Right, right, heard Mr. R. Bopudari, then counsel for the state applicant, for the applicant statement. And Mr. B. Deka for all the respondents barring
4 and 5.
number 4 and 5. Consider the submissions made by the parties. Now considering the fact of the case, we are of the view that the impugned judgment an order dated 14/11/2024 passed in WPC 5616 of 2020 and remains state.
Main matter is coming up for hearing.
Inasmuch as the main matter, inasmuch as the writ petition would be taken up for admission hearing on 23rd.
23rd of September.
Obliged.
I'm so obliged.
I dispose.
Deeply obliged.
Time being item 9.
I'm sorry, my lord, I was 58, my lord, the termination order. Page 58.
No inquiry was held
No inquiry was held since, my lord,
under 311(2).
to Proviso B. And there was an,
Can a DP be held against a retired employee?
my lord,
Can a departmental proceeding be initiated against a retired employee?
no, my lord, since, my lord, he was, my lord, at that time, he was in service, my lord. He retired in,
Now can we give you the liberty to do it? Is it possible as per law?
my lord, since, my lord, he was absent during his service period, my lord, by, my lord,
You see, supposing we set aside the single bench,
my lord,
can we pass an order
my lord,
allowing you to initiate a fresh departmental inquiry?
my lord, this honorable court can, my lord, direct, but before that, my lord,
Retired employee, can it be done?
there is another remedy, my lord, legal remedy for, my lord, preferring an appeal, my lord, under rule 13 and 15, which is perimeteria to rule 51 and 52 of Guwahati University.
See, of course, that big, that gone.
My lord,
That issue is gone.
my lord,
The issue is now that as per the rules,
my lord,
because discipline appeal, the provisions of the rule 9
my lord,
or rule 7, the punishment could only have been given on pursuant to a inquiry to be initiated.
my lord.
Then without an inquiry, it could not be done. That's what the then singer said.
My lord.
Is it wrong?
Milord, since Milord,
No, is it wrong or not? What the decision of the finding of the learner single day?
in view of that legal perceptions of this proviso B, Milord, it is wrong. Since Milord, he chosen to be absent for 2 years and 3 notices have gone to him. One advertisement also Milord published for his presence before the university authority. And in view of that proviso B, Milord, may I read Milord that proviso? Milord? Article 311(2). Milord. No, Constitution. And this constitution bench judgment in Tulsiram Patel is also clear, Milord. If it is not reasonably practicable, then Milord, this proviso will come into play, Milord. May I read that proviso? Article 311(2), proviso B.
There,
Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry.
where are you reading?
311(2).
Two, it
Milord.
starts with no such person.
Milord, Milord, down below, Milord, that B, proviso.
You see, please, when you read,
Milord.
please read from the beginning, at least
Milord,
tell us.
I'm sorry, Milord.
You cannot read from the 5th line or 6th line or somewhere in the middle.
Milord,
Please tell us. There.
2, married.
Correct?
No such person as aforesaid shall be dismissed or removed or reduced in rank, except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Next, Milord. Provided further that this clause shall not apply. A, where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or B, this is relevant, Milord. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. Or C is not, Milord, relevant. Where
It says that it is not reasonably practical.
Milord.
So where is
So-
the reasoning?
Milord, in the judgment itself, Milord, that Tulsiram Patel judgments have been quoted, Milord.
That's not a question of Tulsi Ram Patel. It's a question of where is your own satisfaction
Milord.
that it is not reasonably practicable to
Hold that inquiry, Milord.
hold that inquiry. Where is that?
Milord, those
That's
three,
all.
Milord, may I take your lordship to page 50, Milord? Page 50.
Yeah.
It would be relevant to state here that altogether 3 notices, along with 1 newspaper published notice, have been clearly served
This
upon
is
the
your submission, Mr. Counsel.
Milord,
Where is your finding in the office file that noting or note made by the competent
Milord, that-
authority?
that termination order itself, Milord, page 58. Page 58, Milord.
You see, prior to the termination order, you have to record the finding.
Milord,
Why it is not practicable,
Milord, that,
reasonably practicable to hold an inquiry?
Milord,
What is that?
Milord, that office order itself, Milord, that termination order, page 58, Milord. There are 3 notices, Milord.
No,
One
no.
newspaper advertisement, Milord.
You
In
see,
spite of that, he has chosen to be absent, Milord. So it is not reasonably practicable, which is, my lord, clarified in the Tulsiram Patel judgment, my lord, 5 judges constitution bench, my lord.
What does it say?
My lord, may I take your lordship that, my lord, particular, my lord, para, my lord, page 71 onwards, my lord. Honorable single judge's judgment, my lord, that has been, my lord, quoted, my lord.
There is nothing here which says that. It
The
is
first
No, just a minute. In page 58,
58,
there is nothing mentioned that it is not practicable to do it. Where is it? Not mentioned.
my lord, the reasons are there, my lord. So, my lord, Tulsiram Patel is clear, my
The
lord.
council, the reasons can be
Reason
given
must be there, my lord.
and the finding has to be there. You can write anything in a reason, supposing in a criminal case,
My lord.
you write lot of reasons that this. At the end of the day, you have got to make a final finding or a decision as to whether it should go this way or this way.
My lord. So, my lord,
Right, all the evidence, all the reasons are there,
my lord.
meaning all the evidence is there. On the basis of the evidence, you have to either say acquitted or convicted.
My lord, this aspect has been clarified in the Tulsiram Patel judgment, my lord.
Okay,
So that is why,
Okay,
my lord,
okay.
it starts from page 71, my lord. That has been quoted,
Page 71.
71. May I read?
Go to the relevant point. Don't read the entire thing. I saw it. It's around.
My lord, page 1, my lord, 71, paragraph, my lord, 130,
Yes.
down below, my lord.
Yeah.
The conditions precedent for the application of clause B is the satisfaction of the disciplinary authority that it is not reasonably practicable to hold the inquiry contemplated by clause 2 of Article 311. What is pertinent to note is that the words used are not reasonably practicable and not impracticable. According to the Oxford English Dictionary, practicable means capable of being put into practice, carried out in action, effected, accomplished, or done. Feasible. Webster's Third New International Dictionary defines the word practicable, inter alia, next page, as meaning possible to practice or perform, capable of being put into practice, done, or accomplished, feasible. Further, the words used are not practicable, but not reasonably practicable. Webster's Third New International Dictionary defines the word reasonably as in a reasonable manner to a
So,
fairly.
Counsel, where is the finding made by you? Where is the finding made by you that it is not reasonably practicable to hold an inquiry? Where is that use of those words?
My lord, those words are not necessary, my lord. Reasons are important, my lord. Reasons are relevant. Since, my lord, 3 notices, my lord, the entire, my lord, judgment of Tulsiram Patel, my lord. My lord, I may be allowed to read the entire paragraphs, my lord.
No, it's like this. It's like this. You see, whenever a decision is to be made by us,
My lord.
we take your submission, we record the other submission, and then we say that after considering your submission, we find that this is what should be the thing. What should be the final result of the submission.
Final outcome.
Now, out here, you have only said that he was absent. I mean, he has not received the notice on the occasion. And that notices were for him to return back for duty.
My lord.
It is not with regard to any inquiry. It is only to asking him to return back to duty. He did not return. Now, where is the finding made by you that, okay, he is not responding to our directions to return, and accordingly, we should have a departmental inquiry initiated against him. But due to these reasons, it is not practicable to hold an inquiry. Where is
Well,
that finding?
My lord, that Tulsiram Patel is clear, my lord, that those reasons and findings may not, my lord,
Be
find
mentioned.
place in that final order, my lord.
May not be, can be based.
My lord, yes, my lord, only that order of termination, my lord. those reasons and satisfaction may not be placed in that final order, my lord.
I agree.
My
That's
lord.
why I'm asking you, where is the file noting? We don't need the final order. Where is the file noting where you have already decided that it is not practicable, reasonably practicable to hold an inquiry? I don't want the final order is silent on that.
My lord.
Where is the file noting? Where is the decision
That
by you?
executive council's decision, my lord, and the
Where is that?
deliberations, my lord.
Yes, where is that?
In view of that, my lord, this
Where
order,
is that?
my lord,
You show us that your case is admitted, allowed, everything. Only that, you want that.
my lord,
It's a condition precedent for invoking 311. Come to page 73.
my lord,
Come to para 133. Please read.
my lord. The second conditions, 133 and 134, my lord, both.
133, just read
Miller.
133.
The second condition necessary for the valid application of clause B of the second proviso is that the disciplinary authority should record in writing its reason for its satisfaction that it was not reasonably practicable to hold the inquiry contemplated by Article 311(2). This is a constitutional obligation, and if such reason is not recorded in writing, the order dispensing with the inquiry and the order of penalty following thereupon would both be void and unconstitutional. So, my lord, the stress is upon that reason, my lord. And next paragraph, my lord. May I take your lordship to the next paragraph, my lord, 134.
Where is your satisfaction recorded? You're not getting it.
My lord,
No.
it would be, my lord, may I take your lordship that para 134, next few lines.
Yes.
It is obvious, 134, my lord, that the recording and writing of the reason, it is very, very important, my lord, here.
Correct.
It is obvious that the recording and writing of the reason, only that reason, my lord,
Please read. Continue reading.
for dispensing with the inquiry must precede the order
Precede the order.
imposing the penalty. Now, next line, my lord. It goes in my favor, my lord. The reason for dispensing with the inquiry need not therefore find a place in the final order.
I agree. That is what I've been saying all along.
Tulsiram Patel focuses upon
Mr. Counsel, let is very clear.
my lord.
The order terminating his service does not make a mention of the satisfaction regarding that it cannot hold, it's not practicable to hold the inquiry. So what does the Supreme Court say? That it has to be recorded prior to that final order,
My lord.
and it need not be in the final order. So where is that prior order or prior satisfaction
Lord.
recorded?
My understanding of the
Your understanding is
provision,
confused, Mr.
as well as
Counsel.
my lord, that Tulsiram Patel, the focus is upon the recording of reasons, and that satisfaction emanates from those reasons, my lord. So reasons are clear in paragraph 1, and in paragraph 2.
You're only
And the background deliberations, my lord, I'll place those records.
no, there's nothing. You see, the thing is this: there's only one issue. It says in writing of the reasons for dispensing with the inquiry.
My lord.
Now you are relying upon those 3 letters which you had sent to the delinquent officer,
My lord.
and what is the content of those 3 letters? Is those 3 letters pertaining to a departmental inquiry being proposed to be held against him? No.
Yes, my lord.
It is with regard to
Those,
him not complying.
those 3 notices, along with the newspaper advertisement, clearly, my lord, describes the inquiry aspect and the termination aspect of the employee concerned. May I take your lordship to those 3 notices and the paper advertisement? Lord? That is why, my lord.
No.
The reasons are there, my lord. The reasons have been recorded, and the executive council's deliberations and the file notings, my lord, I'll place those records, my lord. But this 134 is clear. In that final order, those reasons,
In the final order, it is not required to be given, that we are agreed to.
my lord.
Agreed to it. Only thing is that prior to that, passing of that final order, whether there is any noting that the satisfaction has been arrived at after giving those notices.
The executive council
That-
deliberations.
This is very clear in this, that prior satisfaction is required after results.
Milord.
So whether there is any noting on that, whether any order has been passed on that, the official or notes.
In the deliberation of Executive Council, Milord, it is the highest executive body of the
The council,
university.
you see, the deliberation of the executive council
Milord.
is not placed before us. Was it placed before this learned single judge?
Milord, yes, Milord. That was.
It was placed.
Yes, Milord. In spite of that, Milord,
It-
and there is another, Milord, vital aspect.
So you are saying that the learned single judge, despite you placing that, has made this observations. Let us see what
Where is
the
that?
single
Where is
judge.
that? Where is that?
Milord.
You have annexed the writ petition, correct?
Milord, that writ petition, affidavit in opposition,
So
and-
is there, I mean, is it there on the court now? Yeah.
Milord,
It should be there then if that has been placed before the single, it should be there.
Milord, that page, I have already, Milord, pointed out the page 50, Milord,
Please, please.
50 of my affidavit in reply. Milord.
I think, you see, they are casting aspersions on the single judge now. You see, if you read para 15 of the judgment,
Milord.
it says here, it is revealed from the impugned order says that the petitioner not having rejoined his service in terms of the notice issued to him. Censor. These notices were only asking him to rejoin.
No, Milord, that is the crux of the matter, Milord. May I take your logic to those three notices, Milord? Whether the termination word was used in that notice.
Okay. Now,
Yeah.
I'm not going into that because you're going to show me something else. Even if, assuming what you're saying is correct, supposing we assume that you were planning to have a departmental inquiry against him on the basis of those three notices issued to him and the newspaper advertisement, where is the satisfaction arrived at by you that despite these notices, he has not replied? So, we are going to initiate a DP against him. But as he has not been replying to these notices, we find that it is not reasonably practicable to hold a departmental inquiry. And as such, we are going to invoke 311(2).
Milord,
Proviso. Where is that?
in that termination order, Milord, may I take your lordship straight to that termination order again, Milord? Page 58. The first para, Milord. The entire satisfaction, Milord, emanates from that first para, Milord. Otherwise,
I'm
it
reading.
would not have been there, Milord.
Read. I don't know what you want.
Whereas Sri Rudrachandra Das, page 58, Milord, who so-and-so establishment branch Guwahati University has been unauthorizedly absent from his duty since 6/2/2019 till date without any information and have not responded to the so-called notices issued on 6/5/2019, 23/5/19 and 26/7/19 and the newspaper advertisement dated 28/11/2019. And this was the background, Milord. Then, Milord, on referring the matter to the Executive Council and pursuant upon the resolution of the Executive Council meeting held on 12/3/2020 by the resolution number so and subsequent approval of the Honorable Vice Chancellor dated 2/9/2020, the undersigned in exercise of the power conferred by Rule 7 so under Rule 46 of so hereby terminates Sri Rudrachandra Das so from Guwahati University service with immediate effect. So the constitutional provision, Milord, constitution provision, Milord, focuses upon the reasons, Milord, and the just satisfaction, Milord.
Yeah. Come to page 70, para 21.
Is
70, para 21. Please read para 21.
para 20.
21.
The materials brought on record in the matter does not reveal that a satisfaction was drawn by the authorities about the impracticability to hold an inquiry in the matter against the petitioner herein. In support of the above submission, Mr. So-and-so has placed reliance on the decision of the Honorable Supreme Court in the case of Tulsiram Patel. So, my lord, in Tulsiram Patel, entire focus is upon the existence of reasons, and the satisfaction emanates from the first paragraph of the termination order.
Heard you.
And
We are going round and round only. Heard Mr. P.J. Fukan. Learned counsel for the appel.
And one, my lord, vital aspect, may I,
Between judgment and order.
my lord, that
That 6/9/2020
provision, my lord.
passed in WPC. Passed by the learned single judge in WPC 6962 of 2021. Should be settled. The facts of the case in brief. No, no, should be settled. Because whereby the appellant's prayer for setting aside the whereby the writ petitioner / respondent number whereby the writ petitioner's prayer for setting aside the order terminating its service was set aside. Okay, next part. The
My lord,
the
my lord, may I submit, my lord, regarding that appellate provision, my lord, the statutory remedy. About that remedy, my lord, learned, my lord, single judge is silent, my lord. My lord, since, my lord, rule 51-52, as well as rule 13 and 15, my lord.
Mr. We have heard you. There's a limit. There's a limit.
Since, my lord, statutory remedy, my lord.
There's a limit
To point out, my lord.
That is not a case you have taken up. Right.
That was the ground, my lord, in my writ appeal, my lord.
Maybe now that there's no bar for this court to take up this matter. Right. Go ahead. The case of the writ petitioner before the learned single judge was that the order dated 24/9/2020 issued by the registrar Guwahati University terminating the service of the petitioner by invoking the provisions of Rule 7 of the Assam Services Discipline and Appeal Rules 1964. Arranged with Rule 46 of the Guwahati University Employee Service Conditions, Conduct and Appeal Rules, 1970. Should be set aside. As much as the petitioner, in as much as no disciplinary inquiry had been held prior to terminating the petitioner's term. Further, the petitioner's termination from service had been done under the second proviso to Article 311(2) of the Constitution without there being any satisfaction being drawn by the authorities to the effect that it was not reasonably practicable to hold a departmental inquiry against the petitioner in terms of Article 311(2) to two. Of the Constitution. Next. The learned single judge on considering the submissions of the parties and the document and the pleading had held that in terms of the judgment of the Supreme Court in paragraph no the terms of judgment of the Supreme Court in the case of Tulsi Ram Patel. No, in the case of Union of India and another versus Tulsi Ram Patel and others reported in 1985 TSCC 389. The conditions, the condition precedent for invoking article about invoking the provisions of clause B of the second proviso to article 311 bracket 2 of the Constitution of India was clearly absent. As there was no reasons recorded or satisfaction given or satisfaction stated as to why it was not reasonably practicable to hold the inquiry contemplated under section and article 311(2) of the Constitution. The next paragraph. It has also stated, the single judge also observed that neither was the said clause B of the second proviso to article 311 bracket 2 referred to in any of the orders passed by the Guwahati University Authority, nor in any of the notes put up in the matter against the petition. Next paragraph. Next paragraph. The learned single judge also held that In terms of Rule 9(1) of the Assam Services (Discipline and Appeal) close rules, 1964. Prescribed that no order could be imposed on a delinquent officer, any of the penalties specified in Rule 7, except after an inquiry held in the manner provided in the said rule. The provisions of Rule 9 of the Assam Service Discipline and Appeal Rules 1964 thus required the procedure to be followed for holding a departmental proceeding against a delinquent and for just give me this appeal rule. What do I say? Prior to imposing any penalty under section 7, under Rule 7 of the Fed. However, without following the procedure under Rule 9, which was mandatory need, the respondent authority invoke the power under Rule 7, write the impugned order dated 24/9/2020, terminating the service of the writ petition. Next part. The learned counsel for the appellant of the appellants, that is the Guwahati University, is that what is the ground? Wait, is that
Your grounds are starting from page 18.
is that 3 notices along with 1 newspaper publication have been served upon the writ petition, and despite the same, the writ petition continued to remain absent from his duty. Further, the writ petitioner did not submit any appeal / review application against it. Impugned termination order under the provisions of the Guwahati University Employees Service Conditions, Conduct and Appeal Rule 97. Prior to approaching this, he submits that when there is an alternative efficacious remedy available, the learned single judge should not have entertained the writ petition and should have directed the writ petitioner to approach the appellate / review authority in terms the Guwahati University rules. He submits that. He further submits that there is no infirmity in terminating the service of the writ petitioner in terms of clause B of the second proviso to Article 311 bracket 2 of the Constitution. Inasmuch as the same has been made in line with the judgment of the Supreme Court in the case of Tulsi Ram Patel. Accordingly, submit that when the provisions of the second proviso to Article 311(2) of the Constitution has been complied with, there was no occasion for the learned single judge to have allowed the writ petition by setting aside the impugned order dated 24/9/2020. We have heard the learned counsel for the appeal. We have also perused the documents on record. The impugned order dated 24/9/2022 states as follows. Where is the page? Where is the impugned order?
58.
Page 58, huh? You take it down, huh? Next para, a perusal of the impugned order clearly shows that there is no satisfaction recorded by the authorities to the effect that it was not reasonably practicable to hold a departmental inquiry against the writ petition, to have enabled the respondents to have invoked, to have enabled the appellants to have invoked the second proviso to clause B of the second proviso to Article 311 bracket 2. Yes, sir. We have also there is nothing on record to show. There is nothing on record to show that any satisfaction had been arrived at by the authorities to show that they had made a finding to the effect that it was not reasonably practicable to hold a departmental inquiry against the writ petitioner in terms of Article 311 bracket 2 of the Constitution. Prior to that's of course. Yes, sir. Paragraph (133) and 134 of the judgment of the Supreme Court in the case of Tulsi Ram Patel, Supra, clearly provides that the Supreme Court provides that the disciplinary authority should record in writing its reasons for its satisfaction that it was not reasonably practicable to hold the inquiry contemplated by Article 311(2). Prior to imposing the penalty inflicted upon the delinquent officer. It has held that this requirement is a constitutional obligation. And if such reason is not recorded in writing, the order dispensing with the inquiry and the order of penalty following thereupon would both be void and unconstitutional. Next one. Para 133 and 134 of the decision of the Supreme Court in Tulsi Ram Patel Supra states as follows, page 73. Is there. Next. In view of the fact that the respondents have not, the appellants have not been able to show that they have made any recording of their satisfaction that it was not reasonably practicable to hold an inquiry under 311(2) of the Constitution prior to invoking clause B of the second proviso to Article 300(2) of the Constitution. We do not find any grounds to interfere with the judgment of the learned single. The writ appeal is accordingly dismissed.
Lord, regarding the appellate provision, Lord, statutory.
Yeah, regarding, okay, right, one thing, with regard to the submission of the learned counsel for the appellant, that there is an alternative remedy available, it would be profitable to refer to the judgment of the Supreme Court in Whirlpool, for instance, I'll give it, okay. In view of the decision of the above, and as the use of Article 226 of the Constitution is a discretionary power, we hold that we are of the view that as the single judge has already taken a decision on the matter, and keeping in view the facts of this case, we are of the view that the present appeal should be disposed of by this court, and the matter should not be sent. And the writ petition should not be sent, should not be sent to the, should not be sent to invoke the alternative remedy available.
Most obliged.
Delivery of order.
The Ministry of Justice shall release the area funds of 10.84 crores in respect of the 70 scheme within 2 months. The Chief Engineer, Water Resource Department, has been given the communication by the Office of the Accountant General, audit assigned with regard to non-release of that 63. In respect of the 4 schemes, shall submit replies to the communications made by the Accountant General within a month from today, and the Accountant General shall decide the same within a period of 1 month. Okay. Then further period of 1 month. The Chief Engineer, Water Resource Department shall certify the correctness of the certificates issued by the various engineers with regard to the contract. Okay. And thereafter pay the admitted amount. The state and central government will have to pay the bills of the contractors for the work done, even on the foreclosed schemes. If the work orders had been issued prior to the foreclosure of the schemes in the year 2009. As per their respective shares. Entire exercise should be concluded within 6 months. I have given a various things. Two of the writ petitions I have segregated.
Order that is 17.
Mr.
May I please your lordship? Well, in this case,
Name.
BK Shan.
Heard Mr. BK Sen, learned counsel for the applicant who submits that there is a delay of 127 days in filing the appeal. Ms. A. Begum, additional PP, submits that she has got no objection to the delay being condoned. Accordingly, the delay is condoned. I register to list the appeal after a week.
Well, lordship may fix a date, my lord, otherwise it will not be listed.
Huh?
Lordship may fix a date, my lord.
No,
for-
Delay of condemnation, my lord. The objection not filed by.
Have you? So.
Respondent are notified any objection, my lord.
Huh?
Objection,
4,475 days. Any objection?
Why they have not come? Have,
You have to file a written objection or what?
no, my lord.
Not objecting.
No, we are not going to file the objection, my lord, written objection. But we are objecting the, my lord, the this IA for condonation of delay, my lord.
That's what, if you are really objecting, you file a written objection. Otherwise, if you are just for the naam ke vaste say, if you are going to do it, then it's different.
Then we will file an objection.
Okay,
We will file an objection.
Mr. J. Payan, Learned Standing Counsel, is granted how much, and who else? Granted
2 weeks, my lord.
2 weeks time to file written objection. This is the matter of 2 weeks.
oblige, your lord.
May I please your lordship?
Miss
A Lala.
A. Lala, appearing for the applicant, submits that there is a delay of 373 days in filing the appeal against the judgment and order dated 20/06/24, passed in WPC 2163 of 23. To notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondents by registered post with AD within 3 days. This is the matter of the full.
Item 20.
Please, your lordship.
Yes.
Lordship, in this matter, Mr. P Nayak appears. Lordship may take up the matter after some time, lordship.
It's 110 days. Any objection?
No, lordship. Lordship, he'll appear. Actually, I cannot appear for the petition. I am for one of the respondents, but has requested to pass over the matter for the
Okay,
time.
anyway, I'll
time
hear
limit.
him. Any objection?
My lord, first of all, I filed in KBA actually. So the KBA time has expired. Now, my lord, I've got instruction to appear. People also allow me, my lord, in that case, I like appear today and file my power along with my,
Okay, that's not a problem.
my lord.
No, do you want to?
So for the delay is concerned, my lord,
Delay.
I can say, lordship may, my lord, condone it.
Okay, right.
Here, let the matter come up for admission.
Yes, yes.
That's what my.
And Mr. P. Nayak, Learned Counsel for the applicant, who submit that there is a delay of 110 days in challenging the judgment dated 4/11/24, passed in WPC 364 of 2022. Mr. M. Nath, Learned Senior Counsel appearing for,
Respond number 1.
that is point number 1. Submits that he has got no objection to the delay being condoned. Accordingly, the delay is condoned. I is accordingly disposed of. Then list the matter. Right.
It will be numbered and then, my lord.
List the appeal when? When do you want?
I have not got the copies yet. 2 weeks, make it 2 weeks after.
List the matter after a week. Okay,
My.
Deeply obliged.
give a copy.
Lordship, I'll hand over copy. Deeply obliged.
26.
Lordship, on the last occasion, we have been directed to take steps and take dusty mode.
Get the affidavit. We file it. When? Tomorrow, today.
Lordship, after a week.
Why?
And Lordship, in the writ petition, there is an inadvertent error. We have written OA number 59,
That
159.
cannot be corrected like this. You know, on oral representation. Right, Miss
B. Shaha,
B. Saha appearing on behalf of
S. Sharma.
the petitioner submits that affidavit of dusty service on the respondent, number 4. Number 4 shall be filed when? Within 2 days. 3 days. Okay, within 4 days. Please now. 3 and 5. 3 and 5.
3 and 5.
Shall be filed within
Mhm.
how many days?
After a week, next week.
After a week means kingdom come also, madam. There has to be outer limit. It's like saying, I am going to America after 5 years. 5 years means it can mean 20 years, 25 years, 30 years, 35 years. Give an outer limit.
After 4 days.
Within 4 days. This is the matter after 4 days. Respondent number 3 and 5. This is what. This.
Meet pieces. No? My apologies, my last occasion I was not present.
This is what? 302.
302, my lord. The matter pertains to matricide, my lord. The accused allegedly killed his own mother, my lord. And thereafter he slit his own throat.
Oh.
Now, insofar as, my lords, the commitment of the crime of murder is concerned, my lord, it has been established through eyewitnesses that the accused has committed the crime. The only plea, my lord, which is taken and which is not appreciated by the trial court is the plea of insanity under section 84. Now, my lords, going through the materials, all the evidence which was adduced during the trial would clearly show, my lords, the unsoundness of mind at that particular point of time. Now, my lords, the accused, my lords, after hacking his own mother with a dao, my lords, tried to kill himself. And from the evidence, it would appear that there was no previous altercation or any bad blood with the mother. There was no altercation, there was no fight with the mother. And during the 313, when the accused himself was examined, he admitted that he killed his mother. But on being posed the question, why he committed the crime, he said that at that point of time, I was not aware what I was doing. In fact, my lords, after the alleged crime, my lords, he was taken to the hospital and he was there for 42 days. And unfortunately, my lords, the investigation, the police, my lords, they did not even examine the doctor who treated him, and the medical records were also not produced before the trial. My lords. Now,
was he evaluated?
No, he was never evaluated. Now the fact remains, my lords, to satisfy the ingredients of 302, 299 has to be satisfied. 299 culpable homicide. Now, intention is one of the.
Once they die, culpable homicide is there.
Yes. So intention to be culpable homicide, for it to be murder, the intention on mens rea has to be there, man. Now, 84 is the exception, man. And my lord is aware, for 84 to be pressed into service, there is a presumption that there is a presumption against it, that he was not of unsound mind. So the burden is on the accused to prove that he was of unsound mind. So that is the law, and because 84 has to be proved by virtue of 105 of the Evidence Act, which says that there will be a presumption against it. Now, whether that presumption was ever rebutted, 105 of the Evidence Act, it says, my lords, because any of the exceptions of the IPC 80, 79 to 86, I guess.
Anyway, so how long will you take?
Well, it will take some time. I have got some judgments also, my lord. But I would request my lord.
Parthead matter which has been.
This matter was seen by Ms.
Honorable
Priya,
Madam.
my lordship, and I thought that the parthead will start. So I told.
Yes, so we'll adjourn this matter for.
Get some time to research further, my lord.
When, next week?
Any day, my lord, when your lordship.
Okay, this matter after a week.
The earlier order, my lord, there was some.
There's an order. Oh, babe. Oh, yeah. No, you have come here. Yeah, right. Yeah, my case Pure is at present. This matter. However, due to partner matter that is yet to be heard, this matter is adjourned for a week.
I'm very grateful, my lord.
May it please your lordship. My lord, as your lordship on the last occasion have seen, that there is a case where 4 persons were convicted under 302, though 34 is not there in the impugned judgment. With the aid of 34, 3 of them with the aid of 34 were convicted under 302, 34.
You are for?
I am for appellant number 4.
And this was what? Appellant
Number 4.
number. Who is appellant number 4?
Appellant number 4 is Pranav Datta. Pranav Ashish Datta. Now, my lord, to bring home the guilt, my lord, the prosecution examined as many as 15 witnesses. Out of these 15 witnesses, if I need to segregate, 7 of them are eyewitnesses and 3 of them are those witnesses in front of whom dying declaration was made. And there were other 5 witnesses who were the doctor, inquest magistrate, IO, and 1 hostile witness. Now, my lord, this paper, well, the small sheet of paper which I have given, it will. I have segregated the witness as to who are the eyewitnesses, who are the witnesses before whom DD was made, and the other witnesses. Now, my lord, how I propose to start my argument, I will first try to satisfy your lordship that in this case, the appellant number 4 was never identified. This would be my first limb of argument.
This one is appellant number 4.
Appellant number 4 was never identified in the entire course of trial. That would be my first limb of argument. If I fail in my first limb of argument, then my second limb of argument would be that there are inherent contradictions and inconsistencies in the eyewitnesses which make them, not of credit. Untrustworthy, to be specific. Inherent contradictions. And if my second limb of argument can't cut eyes, then, my lord, I will argue on, even if we agree the version of the eyewitnesses, even if we agree that no appellant number 4 was identified, in that case, I'll argue that whether in the given case, this present applicant with the act attributed to him can be convicted under 302 with the aid of 34. Whether 34 can be of any help to convict this appellant number 4, life imprisonment, 302 with 34. Whether common intention can be inferred in this case or not. Common intention to murder. and I shall also demonstrate during the course of my argument that there is no motive in this case. Rather, evidence says otherwise. That there is no enmity. Not one witness, not two witnesses, several witnesses say. So what propelled this crime? So I want to start with my first limb of argument that this appellant number 4 was never identified during the course of trial. Now, my lord, it is an admitted position of fact in this case that there was no TIP. It is admitted position of fact. I need not labor much on this. It is also an admitted position of fact that there was no doc identification in this case. These two are admitted position of facts. Not even a single witness, be it eyewitness, be it otherwise, has identified any of this for that matter, my lord, appellant in the doc. Now, my lord, I'll give you paper book. My lord, there were 7 eyewitnesses, my lord. In the 313 statement, 16 pointed questions were put to the present appellant. Out of these 16 questions,
yes,
7 questions relates to as to whether I know those witnesses or not. In answer to all these questions, I said these are entirely false evidence. My lord will kindly come to.
No, but that you have not answered the question. If the question was, do you know those?
No, my lord, the question was not in that nature. My lord, I'll
say that. So please, you see, when you when you make a certain submission, please answer that the manner it has been stated.
My lord, my lord.
Your question was, the question put to you was that, do you know these witnesses? So you have to say either yes, I know, or I don't know. I'm not saying that you cannot say the hamburger was very good or something.
No, my lord, hamburger. What I'm trying to say is that, my lord, the question.
You cannot give a totally out of context answer. That's what I'm saying.
No, my lord, because my lord will kindly come to page number 59. We'll see the nature of the question. This, it was not a specific question. It was hidden in a big passage. This line was hidden somewhere. Kindly come to page number 59. That is the 313 of the present appellant, Pranav Ashish Datta. Page 59, my lord, is there?
Yes.
My lord, the questions are not numbered. So we'll have to go by this PW. PW3, that is the eyewitness number 1. PW3, Purnima Sharma Datta stated in her evidence that informant is her husband. She knows it should be you. She knows you. On such and such, at about such and such, the occurrence took place in front of her house on the relevant day at about 11 a.m. Pinaki Day told her that one Shibu warned her that Shibu, my lord, I will skip all these things. These are all what she stated in her depositions. And then he was taken to hospital and all these things. What is your answer? He says, it is false and I am falsely implicated. I am not present at the place of occurrence. That whatever you said is false, which includes taking hospital, you know me, no qualification. Because I'll come to the later part.
Basically, he does not know PW3 also.
3, because my lord, in the because there are 4 accused persons. Your lordship will see the answers pertaining to the other accused person. My lord, this is just one question which I have shown. Now, my lord will see number 4, page number 59. Shibu Shah stated in his evidence that he knows you and the informant. The occurrence took place in the year 2013 at 6:30 p.m. in the evening of Vijaya Dashami. The occurrence took place in front of his shop and near the second gate of informant's husband. On the day of the occurrence at 10 a.m., you and Pranav Ashish Datta came to his shop and told him that Pappu and Pinaki shall remain in safe side. In this regard, he informed about the same to the victim Pinaki at the time of occurrence, the Pinaki and all these things. The answer was, I was not present at the place of occurrence at the relevant time. I was at home.
But there was direct reference. He knows you and the informant.
My lord, yes. My lord, I was about, because save and accept the PW4, my lord, will just keep a separate mark for PW4. I'll come to PW4 because in PW4 there was a question and he said, I was not present at the place of occurrence at the relevant time. I was at home. Kindly mark the, I'm coming to PW4. Before PW4, I'll just try to, my lord, cover the other evidences. PW4, I know, my lord, I'll come to that. PW5, my lord, we'll see. Krishna Chanda stated in his evidence that the occurrence took place in the year such and such in the evening. The occurrence took place in the back side of victim house. He saw occurrence when he was running from Vijaya Dashami. He saw that the accused such and such, such and such, such and such caught hold the hand of Pinaki from behind and accused people with a sharp whip and hacked the neck of Pinaki and they fled away. Upon hearing hue and cry, the family member of the victim came out from their house and nearby shopkeepers were also to the place of occurrence. Subsequently, Dulal, Taposh and some other person took the victim by an auto to hospital for his treatment. What is your answer? My lord, here I say I was not present, but then that question was not put that he knows you or you know him. That question is put to the question relatable to PW7. PW6 is not an eyewitness, so I'll skip. PW7. Bapan Malakar stated in his evidence that informant Papude in his neighbor and he also knows the accused person. The occurrence took place in the year such and such in the evening of Vijaya Dashami near Netaji Road. The occurrence took place behind the back gate of the house of victim. The deceased was sitting on a scooty. Suddenly accused Krishna De such and such hold the victim Pinaki. Then accused people they hacked with a sharp weapon on the neck and chest of Chandra and Purnima Day where also went there. Soon after the occurrence, the accused person fled away from the place of occurrence. The victim Pinaki fell down from the scooty. That Pinaki died in the hospital. He saw the occurrence. What is your answer? I was not present at the place of occurrence. At the relevant time, I was at home. The evidence deposed by him is entirely false. The next eyewitness, PW8. Srimati Leela Rani Devi, the mother of victim, stated in her evidence that the informant and victim deceased are her sons. She knows the accused person. The occurrence took place in the year 2013, such and such in the evening of Vijaya Dashami, while she was preparing tea at home. At that time, her younger daughter-in-law Purnima De told her that the deceased Pinaki De neck was hacked. What did I of the accused persons caught hold of Pinaki from behind. An entire narration. His answer is the evidence deposed by her is entirely false. Similarly, in case of the other eyewitness 9, 10 and 11, he said the evidence is entirely false. From top to bottom, entirely false. Save and accept that evidence of PW4 where the word, my lord, I do not know, my lord, while recording whether it has been a typographical error or not, because what experience we have, my lord, in 313, these are stereotyped answers which are being typed. So, my lord, probably it is an typographical error. Be that as it may, I'll demonstrate from the evidence. Kindly come to page number with regard to PW4, my lord. My lord will come to page number 17, the cross-examination of PW4. Page 15, it starts, my lord. The first line. I know the informant and the accused person. My lord will kindly turn to page 17. Last line. It is not a fact that I adduced false evidence against the accused. So there is a denial of my identification. Now your lordship will see how the other accused persons, in the case of other accused persons, what had happened.
What do we deny? Deny the suggestions. It's a suggestion.
Hello, because the accused will put forth his case by means of a suggestion to whatever little I understand, my lord. Because he cannot adduce evidence.
No, you understand more than me.
No.
We understand very well.
No. Because the version of the accused will come through a suggestion only, my lord.
Correct.
Then
Correct.
he will support it in his evidence. So his version is that I don't deny. My lord, I'll demonstrate on whom the onus lies in such circumstance. Under such circumstance, on whom the onus lies, I'll demonstrate, my lord. Now, my lord, all these appellants were examined under section 315 as a witness. They were defense witness under 315.
How long will you take?
I have prepared, my lord, since yesterday.
Ask you.
It will take some time, my lord, it's
How
difficult.
long will it take?
2.5 hours.
If you not take the entire, we'll finish it today. Your part will finish it.
My lord, I can, my lord, there are 15 witnesses, number
We will
one.
take, we will complete we will try to condense. You see, there are around 50,000 cases in High Court. Your case cannot take up everything. You try to condense a little.
But, my lord, at least the vital things I'll have to. Otherwise, my lord, I'll not be doing justice to my client, my lord.
But then we cannot wait for everything. You see, justice is required in 50,000 cases also, not yours. Yours only one among 50,000.
Because this entire, my lord, this 6-month duration and everything, it is at the instance of the appellant number one. We were, my lord, we were not. My lord, so, my lord, there is no admission on the part of the appellant number 4 regarding identity. And the admitted position remains no doc identification. Now, my lord, will kindly see that all these appellants were examined under 315, my lord.
Now, for doc identification, do you have any citation?
Yes, my lord.
Give me that.
My lord, I want to complete this argument because this is related to doc identification. I want to
You see, you see, there's no point reiterating. You already said doc identification. No, how many times will you say? Now, whether there's doc identification or not, we will see. Now, we want to know the law as to what is the law on that.
My lord, I'll give you a 2025 3-bench judgment, my lord.
Yes, yes. There's no point repeating over and over.
My lord, these are because I'm not repeating because yesterday the senior counsel argued on dying declaration. I'm not even touching dying declaration. In my synopsis, there is no dying declaration. My lord, because the other witnesses, there are questions and there are admissions about identity. My lord, if I don't, I'll have to bring it to the notice of this court, my lord. I'll give that judgment because your lordship will be, because
Just give us the judgment first.
2025.
Yes, which para?
Para number 21. This is a very recent judgment, my lord. 2025 SCC online, SC 1110. This is the latest holding the field. The first one starts from 1955, but this is the latest.
Yes, yes.
Para 21. May I read it?
Yes.
In a case where there are eyewitnesses, one situation can be that the eyewitnesses knew the accused before the incident. The eyewitnesses must identify the accused sitting in the dock at the same accused whom they had seen committing the crime. Another situation can be that the eyewitnesses did not know the accused before the incident. Another situation can be that the eyewitnesses did not know the accused before the incident. In the normal course, in case of second situation, it is necessary to hold TIP. If they know, then doc identification. If they do not know, then both TIP and doc. And an example has been given. Now, if in this case, if they claim that they know prior, then there has to be a doc.
TIP is done, then doc identification is not necessary.
My lord, I have judgments where I have judgments where the.
No, as per the judgment you have just given.
No, these judgments said TIP and further, my lord, it says TIP.
It says there, if it is not held, and if the evidence of the witness is recorded after a few years, the identification of such an accused by the eyewitness in the court becomes vulnerable.
Hmm.
That is all. It is.
Ah.
Okay, identification of the accused sitting in the court and what was it? Okay, that's good.
Yes. Now, my lord, coming to the facts of the case, my lord.
I take the lead, my lord. 1 minute.
Yes, yes.
My lord, coming to the facts of the case, my lord. My lord will kindly come to the 315 evidence part of appellant number 1 at page 76.
Just one second. I think your first issue point was that there was no TIP. Correct?
Huh?
TIP not done by any of the.
No.
No TIP by any PW.
Any PWs.
And doc identification, no doc identification by any. So enough. So now this citation is there. What more do you want? What more are you want? So that part is finished.
My lord.
When there is your cases, there is no TIP done by any of the witnesses. There is no doc identification done by any of the witnesses. So that is your stand. Finished. And then this is the citation. Then what else?
My lord, one additional fact which, my lord, subject to what your lordship says, it's for my sake, my lord, I feel that I should say it to the court. Under 315, 4 people were examined. 4 people, 315, 4 people adduced evidence, defense evidence. The appellants, they stood as a witness in this case under 315.
Correct.
Accused can under 315 and they were. Now, once they came as a witness, prosecution will cross them.
Correct.
These 4 witnesses were crossed on the same day.
So
similar questions were put to 3 accused. Do you know them? Some said yes. In fact, 3 said yes. 1 said yes in the chief itself, and 2 said yes in the cross.
So evidence of appellant under 315.
Where cross-examination was done on the same day, 13/9/2018.
Done on same day with regard to whom? With regard
to all the 4.
appellants.
All the 4 apparents, same day.
So how does it prejudice you?
No, prejudice. My lord, what I'm saying is that for other 3, this question was asked. For me, so my point is this, the prosecution knows that I do not know them. Therefore, this question itself was not put to me. Was not put to me. Relevant page number I will give, my lord. Straight on that line, my lord.
Whether he knows the witnesses or whether he knows the
witnesses.
Okay.
Now, should I indicate it from the paper book, my lord? Those particular, only those lines, not the entire passage. Kindly come to page 76.
Page 76.
76, it is for the appellant number 1.
Yes.
My lord, somewhere in the middle, your lordship will see on the right hand side it starts. I know the prosecution witnesses. Your lordship has found that. So in chief he admitted, therefore no question of crossing. He admits. Kindly come to this.
So this knowing by this appellant would amount to prosecution witnesses also knowing it.
My lord, an inference can be made if prosecution witness say that I know Mr. Biswas, and if I say that I know Mr. Jamaika Singpho, that means that I also know him, because in chief he is saying he knows me. Now, my lord, will kindly turn to the other witness, the other appellant, that is 2 and 3. 2 and 3 did not admit it in their chief. 1 admitted it. Since they did not admit it in their chief, PP crossed them. Kindly come to that part. Page 69 to 72. This is for appellant number 2. Yes. One such appellant is at, because they have not direct, 69 is appellant number 3, page 69.
Yes.
Page 69, the last line. This question, because this is cross part, same day, 13/9/2018. I know the witnesses who deposed before the court. Because this question was asked, do you know the witness? The answer is, I know. Kindly turn to the other appellant that is at page number 74. That is appellant number 2, page 74. My lord is there at page 74.
This Krishna Day is appellant number
Krishna Day is appellant number
59.
3. 3. Kindly come to page 74, appellant number 2, Ochinto Day. My lord is there. Kindly see page 75, 1, 2, 3, 4, 5, 6 line from bottom. I know. Because they did not admit in chief, so they were crossed. One admitted in chief, so no question of cross. In my case, this question even was not put because they know that these gentlemen, because I was suffering, my right leg was gone. I was in Patna. Those things I'll come later. So, my lord, therefore, in such situation, it becomes imperative for the prosecution for doc identification. Now, in this case, admittedly, no one identified me. Not even a question was put to me. And interestingly, my lord, all these 4 persons were cross-examined on the same day. It cannot be, oh, I forgot. 7 days back, I cross-examined. 10 days back, I cross-examined. 13/9/2018, same day. अच्छा, इसका judgments note दो, doc identification per.
You have given me one judgment.
Yes. I'll buttress my argument with a couple of more, my lord.
Don't give too many. It's not
Yes. On
number that's going to help you.
No, that is why I gave the recent one first. Now, one more is how this doc identification, it is not that they'll have to, it can be by gestures also, nodding head, by pointing to by pointing two fingers and everything, my lord. That judgment is 19 AIR 1955, Supreme Court 104, para 19. SCC citation is 19. This is the SCC citation 1954 to SCC 516, para 21. Here it will be para 21. How identification has to be done, it cannot be inferred from anything, my lord.
But you said there is no identification at all. So
Yes. So this paragraph also says that doc identification is imperative. But my point is, entire point is this, that identification cannot be inferred from facts. It has to be through these modes. It is kept in the clear process of identification by identifying witness involves the statement by the identifying witness that the particular properties identified were the subject matter of the offense or the person identified were concerned in the offense. This statement may be expressed or implied. The identifier may point out by his finger. Mere statement will not do. This has to be coupled with.
And then
Next, my lord. That famous Manu Sharma case, Jessica Lal murder case, my lord. 2010.
What do you want to show?
I want to show, my lord, that in the absence of doc identification, a crime cannot be associated with a particular accused. That's my whole point. This is because it's a very voluminous judgment, so I have only given the relevant page. It runs through 100 or 200 pages, my lord. Para 258.
Why your client not giving you enough instructions?
My client is inside the jail, my lord. It's only because there is an. So your lordship can understand our predicaments.
All the top lawyers are being engaged.
No, I am not in that league, my lord. 258. Para 258, yes. The learned Solicitor General submitted that even otherwise an adverse inference ought to be drawn against the appellant for their refusal to join the TIP. This view has found favor time and again by this court. It is pertinent to note that it is doc identification which is a substantive piece of evidence. Even TIP is also not a substantive piece of evidence. The substantive piece of evidence is the doc identification. My lord, I don't want to increase the number of citations, but my lord, the law as we understand, my lord, is that on identification, the law as we understand is this, my lord, that if you know him from before, then you identify him in the doc will do. But if you are seeing him for the first time in the court, then TIP is must and followed by doc identification. In this case, neither of these two are there. And this fact also assume importance because there is a plea of LEB. And the LEB was, there was a plea of LEB taken by all the accused persons. Alibi, my lord, by pronunciation typical, my lord.
Typical of what?
My lord, MTR problem, my lord. So, my lord, this is my first limb of arguments. That no identification by any of the... your lordship intends to say something?
No. Just reminded me of Mr. Lalu Prasad's Yadav joke regarding TTM.
TTM.
Total Tail Malish. So he said there are a lot of people, you know, they send us to up above, you know, in the sky by doing TTM, including me. That's what he said in Hindi. In Parliament, he said it. It reminded me of that.
Now, I'll come to the witnesses, man. The eyewitnesses. And I'll demonstrate from the evidence of the eyewitnesses that if you believe one witness, you'll have to completely discard the others. If you believe the second eyewitness, you'll have to completely discard the rest 6 eyewitnesses. There cannot be so many faces of truth. Truth is one. My lord, since your lordship has told about Lalu Prasad, it reminds me of Swami Vivekananda's one famous quotation. He said, truth is like sun, S-U-N. There cannot be his son, my son, your son, their son. Son is one. There cannot be his truth, my truth, half truth, full truth. Truth is truth. Truth is like sun. So now we'll have to see who is speaking the truth. Whether the evidence of PW1 is the sun, is the truth, 2 truth, 3 truth. Because one belies the others.
I don't know, depends upon many things. What about religion?
Pardon, my lord? Or religion?
Yes. I don't know what your truth might be different from a person professing another faith.
My lord, because those are mythological things, my lord. I'm talking of facts, objective things, my lord. Those are religion and other scriptures, and those are subjective, my lord, person to person. But objective, like how many...
Something that can be seen.
Seen, tangible, touched. Yes. So to start with the first prosecution eyewitness, that is PW3, Purnima Sharma De, wife of the informant. He has her own version of the story. Now, my lord, will see there are 7 eyewitnesses watching an incident like a 2020 match. Nobody tries to intervene and nobody recognizes the presence of the other. They only know the incident and they have their own way. Only 2 lines are common.
When you go to a football match,
my lord,
and you watch 2 famous teams playing against each other,
pardon,
I don't think you'll be noticing your neighbor eating chana or something like that.
My lord, I will be provided the audience is only 7. If the audience is 7, my lord,
if you were watching a cricket match and they were in the last over, 6 balls left, 7 runs required, I don't think you'll be bothered about whether someone is there dancing or anything.
My lord, to compare a cricket field with a small
What do you
square
think?
feet.
Well, out here, when someone is stabbing someone, that is the allegation.
Yes.
When someone is stabbing someone, that neck cut did not happen by itself. It happened because of something. So when someone is watching an incident like that, it is quite serious. You'll be quite intent. It's not like two boys playing marbles or something like that. It is.
But my lord, the way they have tendered their evidence would demonstrate.
No, I'm not on the merits of the case. I am just on the fact that, when something happens, interesting happens, maybe bad thing, good thing, what.
No, my lord.
You're totally concentrated on that.
No, my lord, something, if an incident happens in this courtroom, my lord, I will definitely, if I give a statement that it happened in the presence of him, at least few people whom I know. That is what common human psychology. To lend, in fact, I'll say this to lend credence to my statement.
Okay.
That this happened in his presence.
Okay.
PW3, my lord, will come. Page number, PW3, your lordship will find at page number 12. The informant.
Yes, correct.
The informant is my husband because the informant is the brother of the deceased. The informant is my husband. I know the accused persons. At 6:30 p.m. on 14/10/2013, the incident took place in the front of my gateway. Kindly mark that, man. In the front of my gateway. It's a very vital piece of evidence. My lord, I will not make my submission based. At about 11 a.m. on the day of occurrence, Pinaki came and told me that Shibu had warned him and my husband. Accused Munna Dotto had a disagreement with my husband owing to a monetary transaction. Pinaki is the brother of my father-in-law. This is important. Pinaki is the deceased. Now, which Pinaki she is referring to?
Let's see from. For that, will be needed.
The record is.
That can be checked, man. That can be checked. Because sometimes for translation also.
Because this is a vital thing you have been pointing out.
Absolutely. Absolutely.
Mr. Kamal was also.
Yeah, there was, I remember that name, his name.
No, this gate. The same thing you're bringing it up. He said this. He was mentioning this.
No, he was mentioning the name of his client as.
Yes. He was mentioning this gate.
So let us see.
Acha.
In front of the gate, there are two persons.
Maybe the backside falls in the front way. That may be.
We do not.
The back lordship is only a square, nothing is.
Correct. We do not. There's no mention of where is the front gate or back gate. So we'll see from the thing. My brother will see that.
And also your lordship will verify this. Pinaki is the brother of my father-in-law.
Pinaki.
That a deceased, she is saying the deceased is the brother of my father-in-law. That is
Well, whether it is the father of the grandfather also, how does it matter?
It matters, my lord.
Because at the end of the day, he's still a dead person.
No, my lord. Which Pinaki died?
Which Pinaki died?
Which Pinaki died? He is saying that.
Well, you see, there's a Pinaki who died anyway. So you mean to say that the Pinaki that died, has got some relevance?
Yes, my lord.
How?
My lord.
He's the same person who died there.
My lord, then we'll have to go for inference. My lord.
Yes.
Because she says that Pinaki, that means the deceased, is the brother of my father-in-law, whereas that is uncle-in-law. But his uncle-in-law did not die. If you believe the rest of the witnesses,
Father-in-law is not uncle-in-law. What is it?
brother of father-in-law will be uncle-in-law, my lord.
Brother of father-in-law will be uncle.
Uncle-in-law.
Okay, this is the brother of the father-in-law, that's all.
Yes, but that is
You don't have to make up a new word now.
Ah.
Father of the brother of the father-in-law.
brother of the, I'll go the longer way. Brother of the father-in-law.
Ah.
So if that be so, then he is not tendering evidence with regard to the death of the brother of her husband. Because the brother of her husband would be her brother-in-law. He's tendering evidence of a person who died, who happens to be his father-in-law's friend, brother.
Just give those factual things.
No, my lord, at the end of the day, my lord, we are in a criminal case, my lord. So, my lord, the facts will have to be proved beyond all reasonable doubt.
Correct. That we will prove. We'll try.
Yes.
If it is not proven, then you are lucky.
My lord, because the lacunas cannot be, surmise cannot take place of.
They're checking.
Yes, that they can check it because I am also relying on the English translation. Now I'll go forward. In front of our gateway, around 6:30 p.m. on the day of occurrence, accused Ochinto De, Krishna De, and Pranab Ashish Dotto had held both the hands of Pinaki on the back and accused Bipul De first hacked at the neck of the Pinaki with a sharp weapon and then hacked at his chest. The accused fled away when they saw me. I went to the place of occurrence immediately and saw Pinaki bleeding from the neck and chest. Later, I called my mother and with the help of one of the brothers. Now, this, my lord, this mother is missing in the evidence. Later, I called my mother and with the help of one of my brothers of my father-in-law. Her father-in-law has so many brothers, I don't know. How many brothers, my lord, I don't know. I went to the place of occurrence immediately. No, absolutely, my lord. And with the help of one of the brothers of my father-in-law, I took him to Lanka hospital for treatment. But as he was found to be grievously injured, he was referred to Ham hospital. Pinaki died in Ham hospital. Later, my husband lodged an Izahar.
Pinaki moved hypo. That is translated, they have, it is right. Pinaki is my brother-in-law. In Assam, as it is pronounced.
Okay, he's a brother-in-law.
Brother-in-law.
Okay.
I hold it. But it is yesterday also there were some printing mistakes. Otherwise, we prepare a case. No, I believe the procedure. अरे आपने ये तो केले हमने बोला. नहीं ना लगा आपने कोले हुए से. Because my lord, we prepare.
Means Bhayapahood is brother-in-law.
Absolutely, my lord, I know that.
They are basically translating in.
So they have translated wrong. So
no, my lord, the problem is nothing, my lord. The problem is that in the chamber, my lord, we burn the midnight oil, we have our thought process, and then in court we come up with some different facts.
What to do? Luckily for me, I have got a Assamese brother here who can read it. If there was another non-Assamese brother, you might have been lucky.
No, my lord, I don't. We don't want to take advantage of all this. We believe it.
You could have asked a junior to go and check out also from the original. You had this opportunity in the trial court also. In the trial court, there was no translation, I think.
The trial court advocates were different. So, anyways, my lord, so fine. Pinaki is the brother. So it is, I'll read it as Pinaki is my brother-in-law. Then it is correct. Pinaki is the brother-in-law. Exactly, that should be the thing.
It's the record only, it's brother-in-law.
It's okay, my lord. I'm not making argument because this was because of the paper book. Now, the cross part. Accused Bipul came from his home and came along the road. I did not notice Bipul coming. Now, my lord will kindly see. Here he is talking about only Bipul. That's the appellant number 1. I did not notice as to what weapon he brought with him. I was at the place about 25 meters away from the place of occurrence. It was a bit dark at the time of occurrence. Street lights were on. I did not scream upon witnessing the incident. That is also a very unusual behavior from a lady. Very unusual behavior. It is, he is calling his mother. He is calling his...
From your personal experience,
My lord, women naturally have, I mean, I'm not being gender.
That's neither here nor there. You see, there's no hard and fast rule that a lady will always scream.
It is not fact that I did not tell police that both hands of Pinaki had been kept held on the back. I was alone there. I was alone there. That is what I said, my lord, in my at the inception, my lord, that if you believe PW1, you'll have to totally discard the presence of the others. I did not talk to Pinaki just after the incident. The incident took place some 10-15 meters away from the gate of our house. I did not lodge Izahar with the police station as regard the incident that had taken place at 11 a.m. We did not approach Shibu and interrogate him. I thought that this threat had been issued since my husband had enmity with accused Munna alias Pranav Ashish Dotto. They had been having this enmity. Now, this is, my lord, this helps my case. What he is essentially saying that me has some enmity with the informant because her husband is the informant. No enmity with the deceased, enmity with the informant. Because in GD entry, my name does not surface. My name paratrooped in the FIR, which was lost after 5 hours of the incident. And this is a reason, it gives a reason why my name was implicated, because there is a monetary dispute between her husband, informant, and me. That is why he has wrote to in me. They had been having this enmity as a result of monetary transactions since a year before. My husband was to receive an amount of 1,25% from Munna. Pinaki told me that Munna and Ajay had told Shibu. I did not see weapon in the hands of Ochinto, Krishna and Pranav. Prior to the incident, no fight took place between the accused and Pinaki. No fight. Pinaki is the deceased. So no enmity with Pinaki, the deceased. No fight, no altercation. A 2-3 feet high bamboo fence was there between the place where I was standing and the place of occurrence. I witnessed the incident. Pinaki's cloth got stained with blood. It is not a fact that the accused did not commit any incident in the manner I have stated about the same. It is not a fact that Pinaki did not tell me that Shibu had warned him and her husband. It is not a fact that I did not witness any incident. It is not a fact that my husband lodged an SIR on false ground since there had been an enmity since the previous year. So this suggestion was also given. As far as I know, my husband lodged an FIR 1.5 hours after the incident. That is also wrong. But I'll not skip all this. After the incident, some 40-50 people gathered at the place of occurrence. Now, my lord, will kindly turn to page 46, the IO statement. Page 46, the last line.
Yes.
PW Purnima Sharma, they did not state before me that the accused caught hold the hand of the victim from behind.
Accused means which accused?
Here, my lord, accused is because the cutting behind, catching the hands are this accused. 2, 3, 4.
2 people have.
3.
Another person 3 and another person is.
Yes, yes. So in before the court, she is saying caught hold from behind.
Accused, only one accused.
My lord, then her evidence will be neither here nor there. Then how to
Not state before me that accused or hold the hand of both.
accused? Because, my lord, accused cannot, all the accused together will be accused, my lord. Because before he does not implicate the holding people before the this IO. So therefore, my lord.
Yes.
Therefore, my lord, what transpires from the evidence of this, if we believe him to be an eyewitness, to be a very truthful witness, then her to be a very truthful and unimpeachable, my lord. In that event, All other 6 eyewitnesses are lying because she was alone. If we believe him, then there are eyewitnesses who said the incident took place in the front side. Either they are lying. If we believe her, then my lord, she says that she has taken the deceased to the hospital. Other eyewitnesses say no, it was us. Somebody say it was they. That is why I said to believe one eyewitness, we'll have to discard the other. Coming to the next eyewitness, my lord. Page 4, Shibu Shaha. It's a nearby shopkeeper. PW4, page 15. I know the informant and the accused persons. Around 6:30 p.m. on the day of Dashami of Durga Puja in the year 2013, the incident took place in front of my shop and near gate number 2 of the house of informant. My lord, I take a pause here. The incident took place in front of my shop and his name is Shibu Shaha. Kindly turn to 143. My lord is there, my lord?
Yes.
My lord, I've seen the lot of shops opposite B, C, D, E, F, G, H. My lord, will kindly turn to the next page, 144. I searched in vain the name of Shibu Shaha. How can his place be in front of the place of occurrence? These are all manufactured witnesses. Yes. Then, around 10 a.m. on the day of occurrence, accused Ochinto and Pranab Ashish Dutta came to my shop and told me that Pappu and Pinaki should be on alert.
Are you reading that Shaha? Where is that?
Page 15, PW4, the second eyewitness. The third line, the incident took place in front of my shop.
PW4.
Yes, page 15.
Yeah.
My lord, I know the informant and the accused person. Around 6:30 p.m. on the day of Dashami of Durga Puja in the year 2013, the incident took place in front of my shop. I'll come to his cross part.
Now, where is the informant house? At what particular?
Informant house is this place of occurrence, PO.
PO. So that means probably B.
B is somebody else. B is some, PW11 is B. Oshim Haldar is B. Oshim Haldar is PW11.
Tapan Shah is a different person?
Yes. Tapan Shah not examined. Now, the cross part is more damaging. To my shop and told me that Pappu and Pinaki should be on alert. In fact, Shibu Shah's father is Mono Mohan Shaha.
Same person. Tapan Shah.
Where is that? My lord.
Lordship,
Is there anything?
Lordship, I'll have to go to the.
Okay, carry on.
From the evidence, from the trial evidence, I cannot.
Nothing has come.
Trial evidence, nothing has come, my lord. Something which the prosecution does not bring to trial, I am deprived of cross-examining. Now, yes, at the time of occurrence, Pinaki was riding a scooter. Now, this is interesting. Now, this is a very vital fact that the man who died was riding a scooter when he was being subjected to that deadly assault. This entire scooter part is PW1 is silent. Riding in scooter. And thereafter, Ochinto, Krishna and Pranab grabbed hold of Pinaki from behind and then accused Bipul. They hacked at the neck and chest of Pinaki with a sharp weapon. The accused person fled away, hacking Pinaki. Many persons gathered there immediately. Later, Piklude and Dulal Devnath took Pinaki to hospital. My lord, I take a pause here. My lord, your lordship remembers what the other eyewitness said, that she took her to hospital. So, my lord, if I believe now PW2 to be, PW4 to be truthful, then I'll have to discard PW1. Later on, Pinaki died in hospital at the time of seizure of the scooter from the place of occurrence. My signature was obtained as a witness. Exhibit 2 is my signature. At the time of occurrence, I was in the shop where chana is sold. There was no customer in the shop at the time of occurrence. The incident took place in the west of my shop. I saw the entire incident from my shop. Now, this is interesting. My lord will kindly turn to that Papon shop part will also go now. We'll kindly turn to page 143. There now that ambiguity is also go. 143. Now, what he says, the incident took place in the west of my shop. So from the place of incident, my shop will be on the eastern side.
Just a minute. This is Shibu Shah.
Shibu Shah.
So Shibu Shah, where is Shibu Shah?
Shibu Shah is page number 16, my lord. Shibu Shah says that I saw the entire incident from my shop. That the incident took place in the west of my shop. So, if the incident took place on the west of his shop, then his shop will be on the eastern side from the place of occurrence. In the place of occurrence, there is no shop in the eastern side. Page 143. Eastern side, there is no shop. In fact, there is a house of one Mr. Hajarika or Saikia.
But where is Shibu Shah's house, first of all?
That is what I am also trying to locate, which I could not find. He is lying. He said that his shop is in front of the incident place. That is my point of argument, my lord.
But then it could be one of the houses there.
No, he said, if I understand it correctly, that it happened in front of my house and, it happened in front of my shop and my shop is on the western side of the incident, a place of occurrence, western side. So, from the place of occurrence, his shop will be on the eastern side. Now, if we...
If it's on the western side of the incident took place in the west of my shop. We said in the west of my shop, not western side. We said west of my shop.
Absolutely. So, from the place of occurrence, his shop would be on the east.
Yes.
Kindly see whether there is any shop in the east, 143.
No, it doesn't have to be so accurate as such. Southeast. It can be southeast, it can be northeast, it can be something like that.
My lord, my first point is that
It doesn't have to show that all the witnesses' houses are there also. They can be houses a little further away here and there.
Now, my lord, be it southeast, northeast, any direction. In fact, there is no mention of his shop.
True.
So therefore, he's lying. How can he see it from his shop? Because this B shop is somebody else.
Let's carry on.
My lord,
We got your point. We got
the
your
prosecution will have to, my lord, prove a case. It is not
We got your point. Okay.
that the sketch map completely belies or demolishes his claim to be an eyewitness. Because from the place from where he claims to have seen the incident, there is no such shop which belongs to him, neither on the east, west, north, south, southeast, northeast. Because the very purpose of making a sketch map is to lend credence so that see these gentlemen's house are there, so therefore they can see. Now, interestingly, they don't examine the person whose house is on the left and whose house is on the right side. That is my separate argument on adverse inference.
INJ.
INJ they don't examine.
So your basic case is that all the houses or shops of the witnesses are not shown.
No, my case is that the houses of the sketch map of the house, of the place of occurrence shows that these witnesses are making false claim that they have house, they can see it from their shop, which is in front, right, left. They are making false claim.
Okay, next. Let's go.
Now, my lord, this is Pinaki bleed. I did not talk to Pinaki after the incident. I did not properly notice as to what weapon was there in Bipul's hand. The weapon was about 2-3 inches long. I did not see from which direction Bipul came. I did not see any weapon in the hand of this appellant number 224. There was light at the time of occurrence. I did not talk to the accused person at the time of occurrence. When Pinaki was taken to hospital, I did not accompany him. I do not know if there was any enmity between the two parties. I did not ask Pranav Asis as to why he warned them. I put my signature list. Again, my lord, no motive, nothing. So, my lord, Yes, there is one important part, my lord. At the time of the Pikaran providing a scooter, Shibu Shah, according to Pitlu, is it the incident from the shop or the place does the place the shop? Now, my lord, there is one point. In chief, he says that the sharp weapon was used. In cross 180 degree, he did not notice the weapon. Sharp weapon did not notice the weapon. Then again he says in the same breath that the length of the weapon is 2-3 inch. Length of the weapon. Yes. Other eyewitnesses, namely Papan Managa. 18. Now there is a further cross-examination of this witness at page number 18. Now this will demolish the other eyewitnesses. I can read and write. In the year 2015, I went to Chennai. The distance of my shop to Lanka PS takes 5 minutes walk. The occurrence took place just in front of my shop. He is again reiterating in front of my shop. At about 10:30 a.m., Pranab Ashish Date took me to at my shop. I'll skip the. On that day, it was an occasion of Vijaya Dashami. Normally, people busy celebrate Vijaya. On that day, I saw the occurrence by myself. Pinaki Das was sitting on a scooty in front of their gate number 2. I did not put any alarm when the accused person come towards the victim Pinaki. About 50 numbers of people gathered there. After the occurrence, now, my lord, kindly take note of this line. About 50 numbers, my lord, is there about 50 numbers? Kindly see. About 50 number of people gathered there after the occurrence. After the occurrence, 50 number gathered. I did not remember the name of other person gathered there except. So out of this 50% who arrived later, he don't remember the name of except who? Except Bapon Malakar, again an eyewitness. That is PW. Bapon Malakar is PW7, eyewitness. Then the next name he takes Oshim Haldar. Oshim Haldar is another eyewitness, PW11. Then he takes the name of Krishna Chandra Datta. Krishna Chandra Datta is, now there is the Krishna, there is one Krishna Chanda. Now whether that is an eyewitness. Now whether this Krishna Chanda and Krishna Chanda Datta are same, because if it is a Krishna Chanda, then he is again an eyewitness. So therefore, if I believe him, this PW4, then I'll have to discard PW11's claim to be an eyewitness, PW7's claim to be an eyewitness, and PW1's claim to be an eyewitness. The occurrence took place. Rest of the part, I skip. I'll skip the rest of the part because I don't think any submission can be made from this. Now the third eyewitness is Krishna Chanda. Now, in all probability, because we have seen there are a lot of discrepancies in typing mistake and all these things, this Krishna Chandra Datta is Krishna Chandra. That is PW5. So even PW5's claim of being an eyewitness is being belied by PW4, that is the other eyewitness.
But this is after the occurrence.
Yes. So if they, so because after the occurrence PW7, PW11, they came, so they cannot be an eyewitness. Not only they, 50-60% came. Out of those 50-60, he can remember the name of these eyewitnesses.
Next point.
Yes. Then comes the next eyewitness, PW5, Krishna Chandra, neighbor. He claims to be an eyewitness, but no other witnesses have deposed about his presence except PW4, who said after the occurrence. The informant is my neighbor. I know the accused person. The informant took, the incident took place in 2013, around 6:30 p.m. on the day of the occurrence. The incident took place in the rear side of the gate of Pinaki's house. While returning home, after enjoying Vijaya Dashami celebration, I saw accused Ochinto and Munna alias Krishna. I think this is also a typography, this error while making paper book because this says Munna alias Krishna. If Munna alias Krishna, then it helps my case, but I'm scared to make that submission because Munna is not alias. Munna is my alias name. Munna alias Pranab Ashish Datta. But here it says Munna alias Akbar Sabusu.
That should change it. Basically, you are Munna.
No, my lord, I'm not Munna.
Ashish, whatever.
I'm Pranab Ashish Datta.
Correct.
So I'm not Munna.
Because they find you very cute, they're calling you Munna.
My lord, I hope that cuteness also, if that cuteness would have,
I'm not talking about myself, I'm talking about this.
if that cuteness would have some reflection in the impugned judgment, my lord, then that would have been wonderful. In fact, my lord, 7 eyewitnesses, wonderful recipe for conviction. But my lord, if once we scrutinize meticulously these eyewitnesses, it raises more questions than answer. How can it be? They say,
I know, thank you, sir.
where I was, yes. I was accused. I saw accused Ochinto and Munna alias Krishna holding Pinaki's hand on the back and accused Biju hacking at Pinaki's neck, and then I saw the accused person running away. When a hue and cry arose, the member of Pinaki's family came out. Now he is belying PW3. PW3 is the member of his family. Only after hue and cry. So if PW5 is to be believed, we'll have to disbelieve 3. Then Dulal, Taposh and some other person took Pinaki to hospital in an auto rickshaw. Now came another new character, Taposh. Dulal and Taposh, because your lordship remembers the claim of the other. I'll give a discrepancies chart-wise, I'll submit, my lord, on material points. Not this half an hour, 25 minutes here and there. Those are, my lord, I'll not make submissions on those. I heard on the following day that Pinaki had died. Yes. Cross. It is not a fact that I did not tell police. It is not a fact that I did not tell police that Pinaki had been riding a scooter that Ochinto, this appellant number 223, had been grabbing hold of him and that Biju had hacked his neck with a sharp weapon. My lord will kindly turn to page 46.
Yes.
The name of this witness is Krishna Chanda. Now, Krishna Chanda part your lordship will find Krishna Chanda, Purnima Sharma did not. Yes, the last line, page 46, which stands from witness Krishna Chanda.
Krishna Chauhan.
My lord, this is Chanda. There are a lot of these mistakes, my lord. This is not, there is no witness as Krishna Chauhan. It is Krishna Chanda. Witness Krishna Chanda did not state before me that accused such and such did not caught hold the victim Pinaki. Witness. So, accused Ochinto Munna, your lordship, that he has not caught hold. So, for the first time, he's implicating me in the court. Now, my house is 250 meters away from the place of occurrence. I could identify what type of weapon it was. I could not identify, sorry. I also do not know the length of the said weapon. I was at a place of about 8-10 meters away from the place of occurrence. Krishna was behind Pinaki and 2 other persons has grabbed him by his side. Now, in cross, 2 other persons has grabbed him from them. Who are these 2 other persons? He was so specific in chief, in cross, 2 unknown persons. 2 other persons has grabbed him by his side. I did not resist them. He was hacked at the left side of the chest and the neck. I do not know as to why they assaulted him. I saw injury in 2 portions of the body. Pinaki was sitting with his face towards the southern side. I was going from the east to the west. I did not tell police that Dulal, Taposh and some other person and I took Pinaki to hospital. Now, here he introduces himself, Krishna Chanda. Now, the other witnesses, they did not mention about Krishna Chanda. I don't remember when I put my signature. Later, police took my signature at the night. It was now, my lord, according to him, PW6 and one Taposh and some other person took the deceased to the hospital. Whereas according to PW3, it is PW3 who has taken him to hospital. According to PW4, PW10 and 6 took him to hospital. The point,
According to PW,
according to this particular gentleman, PW5,
PW5. yeah.
according to PW5, Dulal, that is PW6, and Taposh, not examined,
Is PW6.
6, and Taposh. Yes, my lord, but they are talking of the first instance because they are eyewitnesses from the place of occurrence. These are all eyewitnesses I am reading, my lord. And
Who is this Dulal Devnath?
Dulal Devnath is PW6. He is not an eyewitness.
PW6.
PW6 he is not an eyewitness. He is the
And Piklu De?
Piklu De is this PW10. That chart, if your lordship sees, everything is there. That one-page chart. I have given the relation and the name and everything.
No, so PW3 says she took the person to hospital.
Correct.
PW4 says Piklu De and Dulal Devnath took.
Absolutely.
And PW5 says
164.
PW6
And
Taposh.
Taposh. Yes.
Who is Taposh?
Taposh is not examined. In fact, they ought to have examined
Took them in what way?
Otto.
Once they all fit in the auto.
That is, my lord, these I told, but these all raises more questions.
Then ambulance. That is all evidence on record, my lord. There is no ambiguity about it.
Yes, my lord. I am
And with
also reading
regard
from
to-
the evidence, my lord. I am also reading from the evidence.
164 also there.
164 days. From hospital, they have taken ambulance to the next.
No, that is all right.
That is.
The first.
First, they have taken auto.
Who and?
By Dulal Devnath and one more Taposh Devnath. Along with Taposh Devnath.
They have stated in their examination chief also, my lord.
But what about PW3? He was there also.
Even there, but 164 was recorded, but it is not based on.
And it is never been suggested that she was not there.
Okay, anyway, carry on.
My
And so
lord,
far with regard to the dogged identifications, my lord.
my lord,
it's
then
been
let
there.
him as a rebut. I'll.
It has been there.
No, that
Yes,
is
yes. Let him finish.
So, my lord, in short, my lord, PW5 for the first time implicates me in the court. PW5 belies PW3 and PW4 with regard to material because the place of occurrence and everything, they are saying front side, rear side. So, my lord, and he is completely silent about the presence of any other eyewitnesses. And most interestingly, none of these eyewitnesses, despite being an eyewitness, and one gave a very interesting statement, I'm coming to that one ago. Nobody could identify the weapon. Yesterday, my lord, I was contemplating what could be the possible reason behind this. The possible reason may be they were apprehensive because the weapon was not recovered, that if the weapon is recovered, it will completely demolish their case.
And that the person with the neck injury died because what? He fell.
My lord, on that given day, if the records of the hospital would be checked, so many people might have died. The issue is whether these people has killed him or not.
No, I'm just asking you, that injury is there anyway on the neck. That
Yes.
did not suddenly appear.
Yes.
Maybe not by you or
Yes.
by your friend,
Yes.
but that person died due to some injury. No one's going to poke their own.
I bow down to what has fallen from your lordship. What I am trying to impress on this honorable court is this, that the whole point is these eyewitnesses, I am reading the deposition of some people who are claiming that I have seen this person killing him. The issue is not whether that person has died or not. I am not even suggesting.
Okay, we got that. Okay, next. Others will never end.
So then comes the next eyewitness, that is 7 Bapan Malakar. Now the presence of Bapan Malakar, if your lordship remembers, has been discarded by PW4. He said Bapan Malakar came afterwards. He said Bapan Malakar, these gentlemen, he came after the incident. But the learned trial court have completely turned a blind eye to the depositions of PW4. The learned trial court has considered both 4, 3 and everyone as an eyewitness. Now, yes, PW7, 6 is not an eyewitness, 7, page number 26. Complainant Papu De is my neighbor. I also know the accused person. We are from the same place. The incident had taken place near Netaji Road at about 6:15 p.m. on the day of Vijayadashami in 2013. The incident took place outside the rear gate of the house of Pinaki De. Pinaki De was sitting on a scooter. All of a sudden, accused Krishna De, Munna De, Bipul and Ochinto came and caught hold of Pinaki. Bipul De inflicted cut on the neck of Pinaki by means of weapon. Then we appeared there. He himself demolishes his own claim of being an eyewitness.
Why? How?
Kindly read this. All of a sudden, such people came, inflicted cut on the neck of the Pinaki by means of weapon. Then we appeared there. So he is corroborating the evidence of PW4, who said that he came after the incident. And then again on the next line, he takes a U-turn. Oshim Haldar, Shibu Shaha, Krishna Chanda and Purnima De also went there with me. Now kindly, my lord, I take a pause here. He said, we appeared there after the cut and everything. We appeared there. Along with him, who all are appearing? Oshim Haldar, PW11. Shibu Shaha, PW4. Krishna Chanda, PW5.
Just a minute. Ashim Haldar is who?
PW11. Check करना तो ठीक है ना एक बार check करना give me this
Shibu Shaha is?
Shibu Shaha is 4.
Krishna Chanda?
5.
And Purnima De?
3. How on earth could it be possible? There is some tutorship, my lord, in this case. Except the 2 line of holding hand and inflicting cut injury, rest hardly corroboration. The next line is more damaging. The accused person had already fled away therefrom. Pinaki fell down from the scooter. The injured was taken to hospital by an auto rickshaw. Later on, I heard that Pinaki had died. I myself saw the incident. Now again, he said, I myself saw the incident. Police brought me to magistrate for getting my statement and all this. I cannot say the name of the weapon. It was held in hand. I cannot say how big it was. My house is about 100 meters away from the place of occurrence. I witnessed the incident from a distance of 8-10 feet. I did not talk to Pinaki. I cannot say from which direction I saw the incident. I cannot say whether Purnima De came before me or after me. Arrangement for light was made for Durga Puja. Hence, I recognize the accused person. Bipul De came at the moment the rest of the accused person caught hold of the Pinaki. Came at the moment, I don't know what the translation. I cannot say from which direction Bipul De came. I did not hear any altercation between the accused and the Pinaki. Again, my lord, no motive. Bipul De came and asked Pinaki why he had assaulted his brother and father. I take a pause here, my lord. Just see, my lord, the dichotomy. This, my lord will kindly see this. He says, he even heard the conversation between the accused and the deceased. Bipul De is the main accused. Bipul De came and asked Pinaki, the deceased, why he had assaulted his brother and father. So therefore, he has heard the conversation just before the incident, but he has not seen the weapon. How on earth can it be possible? He is in so proximate distance that he could hear the conversation. Deliberately, they are trying to manufacture and hide something, my lord. And I stated this in my statement before the magistrate. Definitely, my lord, they were not screaming or shouting, two persons, that they were at such a distance that they were screaming. And their weapon theory will also be demolished, my lord. I saw Krishna, Munna and Ochinto keeping hold of Pinaki from behind. I did not see arm in the hand of rest of the accused. They did not assault Pinaki. The arm was dragged from upward to downward while causing the injury. Now, my lord, I don't know, my lord, how on earth a slit injury, neck injury can be from upward to downward. It is not a case, my lord, where he was teared into two pieces. And he has seen the arm, but he doesn't know the weapon. He have heard he was in such a proximate distance, doesn't see the weapon. Is it some believable story, my lord?
There was a
Chest injury also. Upward to downward. Normally, well, these are the things which raises strong doubt about it.
Normally like this.
But how can I, my lord, I do not, I am not a ninja, my lord. I do not know how this will happen. Only a ninja can do it.
Sure.
I said, ninja, my lord, those are supernatural power, my lord, extraterrestrial power, my lord.
Ninja turtle.
My lord, during my teenage, I have seen a lot of ninja movies, my lord. I am from Nagaland, so I was fascinated by all this.
You were in Nagaland?
Yes, my lord. My father was a cop in Nagaland.
So you live.
I am born and brought up in Nagaland.
You must have visited the shop, the market.
Hong Market. My uncle was the secretary of that part.
So you must have some ninja blood in you.
I know, my lord.
One correction, my lord, in page 27, I have checked the records. The accused person had already fled thereon. It should be, my lord, immediately. Immediately. Because loge loge Asami gone Ghotanasthulir pora gusi jai. That should be the correction.
My lord, in that case, my lord, this paper boot has to be nutun ke banabo. Inka set of mind will prepare hoya hu yate fill up 180 degree ulta. These are, I don't know.
What to do? What to do? No. We will decide. You are on bail.
No, my lord.
You are in jail. Then why do you want to prepare?
Pardon, my lord?
You are in bail or in jail?
I am in jail, my lord. I am
only one of your.
The prime accused, the main accused is.
The prime accused.
The prime accused.
He is out.
He is out.
He's got cancer.
His daughter.
Daughter is.
Supreme Court.
Supreme Court granted bail.
Once
Initially, High Court, then
surrendered also, but time to time he's been going out because of the treatment of her only daughter.
Human miseries have many faces. Yes, ma'am.
But then the crime is also serious. The child is also serious.
And
have to balance.
Have you seen a child who had cancer? It's very sorry.
No, this is
very sorry.
unfortunate.
Very sorry because so innocent, nothing, they're so brave.
Yeah.
Anyway, so where the fled immediately,
The fled immediately, this will even if it is fled immediately, then also it doesn't make any such difference because they came, according to this witness, he along with some other eyewitnesses, that is PW 11, 4 and 5 and 3, they came after the incident. When the occurrence was over.
Immediately, okay.
I cannot say the name of the weapon. And Anna, this already I have covered. Name cannot say, but then can hear the conversation. Then we appeared. That is precisely I say that after the incident they appeared. Then we appeared. And that is precisely what PW4 have also said, that these gentlemen came afterwards.
Next.
Next. The next eyewitness is one Mr. Chatterjee, Manoj Chatterjee,
Item, PW number?
9. Now, this is another, his name I could not find in any place. None of these witnesses, nowhere. Not even after, before, at the time, nowhere his name. He suddenly paratrooped into this ring. Yes, that is at page number 31. I know the complainant and the accused person. The incident took place about 6:30 p.m. on the day of Dashami of Durga Puja in 2013 near the gateway of the house of Pinaki De situated at Netaji Road. Pinaki De was sitting on a scooter. I was nearby. Then accused Krishna De, Achinta De and Munna Datta were keeping hold of the hands of Pinaki from behind. Then I saw Bipul De coming with a pointed weapon in his hand and hacking the neck of Pinaki. The neck got cut. Immediately a cut blow was dealt on the portion of the chest to belly. Now this is a new introduction. Till now we knew neck and chest, now chest to belly. Later on, Bipul told the accused person to flee. Then Pinaki fell down to the ground from the scooter. The accused person has left. Now my lord will kindly take note. The accused person has left. Later on, PW5, eyewitness number 3, PW7, eyewitness number 4, PW6, PW11, eyewitness number 7, Purnima De, the first eyewitness, they arrived. My lord, whom to believe, my lord? Later on, Krishna Chanda, PW5, Bapon Malakar, PW7, Dulal Devnath, PW6. PW6 I'll ignore because he doesn't claim to be an eyewitness. Oshim Haldar, PW11, eyewitness. Purnima De, PW3, eyewitness appeared. Put Pinaki in a auto rickshaw and took him to hospital. Pinaki's person got smeared with blood. At night, I heard that Pinaki died in Ham Hospital. I myself saw the incident. Police questioned me. Police questioned me at the place of occurrence on the day. On the day of occurrence itself. Police did not obtain my signature. My house is not visible from the house of Pinaki. I saw the incident while going to Durga Mandap from the house. There are houses of 25 families in between my house and the Durga Mandap. There are houses of about 10 families in between of house of Pinaki and Durga Mandap. It is not a fact that I did not state to police that I was nearby the place of occurrence. It is not a fact because he did not state that before the police. It was not dark at the place of occurrence. I saw incident in the glow of light. The incident took place on my right-hand side. Initially, there was no altercation between the 3 accused and Pinaki. I did not see the accused person coming. I did not see any arm in the hands of accused appellant 2 to 4. I did not see them assaulting Pinaki. I also did not ask the accused person. I did not see accused Bipul coming. I cannot say what the weapon in the hand of Bipul was. The weapon was about 3 inches long. These are really very strange statement making. I do not know what is the weapon. It is 3 inches long. I did not give the description of the weapon to police. It is not a fact that I did not state to police that the portion from the chest to belly was cut. Bipul inflicted the cut from front. There were shops near the place of occurrence. There were 6-7 shops. I did not try to disperse the quarrel. Outsiders came and saw the injured. It is not a fact that I did not state to police that such and such came to the place of occurrence. It is not a fact that I did not state to police that the rest of the persons also came with us. My clothes did not get stained with blood. It is not a fact that I did not see the incident. Pinaki was my contemporary. He is an interested witness as well. It is not a fact that Bipul did not cut Pinaki. It is not a fact that I was not at the place of occurrence. It is not a fact that the 5 persons I have mentioned above did not come to the place of occurrence. It is not a fact that the accused persons did not come to the place of occurrence. These are all suggestions, my lord. It is not a fact that Bipul had no weapon. I have failed to tell the name of the weapon. I went to Durga Mandap after the incident. I stated. So, my lord, according to him, so if he is to be believed, then your lordship will have to immediately minus PW5, PW3, 7, 3, 5, 7 and 11 from the class of eyewitnesses. Because later on they came. Immediately they go.
Okay, next.
Then he does not know the weapon at the same time.
At the same time, it's 3 inches long.
3 inches long. Now, my lord, there was kindly see, there was a suggestion made to him. And what would be the implication of that suggestion, my lord, subject to correction? He said in chief that Oshim PW 3, 5, 7 and 11 came later. To that point, my lord, I am clear, my lord. Now, kindly see this suggestion. Page 33. It is not page 33, first paragraph, which start with 1, 2, 3, 4, 5th line from bottom. It is not a fact that I did not state to police that that Oshim Haldar, PW 11, 5, 7, 6 and Purnima came to the place of occurrence. It is not a fact that I did not state to police that the rest of the person also came with me. So these persons who came later, that means his statement is that he also came along with him, because he is saying it is not a fact that the rest of the person came. It is not a fact that I did not state to police. That means he has stated to police that rest of the person came along with him. So if rest of the persons who according to him came later on, also by implication means that he came later on. These are the same set of person whom he says came later on. This Oshim, Krishna, Bappa, Dulal, Purnima. Yes, my lord. So, PW 10, my lord. Now, my lord, PW 10 happens to be Piklu De, that is brother of the deceased. Complainant Papu De is my younger brother. Deceased Pinaki was my brother. I know all the accused persons. At about 6:30 p.m. on the day of Dashami of Durga Puja in 2013, I came out of my house to go to Puja Mandap. At that time, I saw my younger brother sitting on a scooter on the road in front of the rear gate. Right at the time, accused Munna, Krishna, Ochinto were keeping hold of the hand of my younger brother. Right at that moment, accused Bipul hacked in the neck of Pinaki.
2-3 minutes, filter will go off.
Absolutely, even I also need to. So yes, my lord, we were on a eyewitness,
But then,
who after who after having seen a gruesome murder have been to Puja Mandap to see the image of God and everything, because after that incident he has gone. Now we'll have to believe that also. But normally, if a man sees a murder, is it believable that he will go to a puja mandap?
I don't know.
Now that is the issue, my lord, because normally, my lord, it doesn't happen. In this society, normally it doesn't happen. In fact, my lord, if we touch a dead man, we'll have to go and take bath and then come.
But
At the
did you
detail.
see what you do? Wash your, give hydro.
No, if you, well, my lord, I'm not justifying any custom, but this is there, man. But because so many people have gathered, somebody instantaneously, my lord, with all, and then he goes to Puja Mandap to enjoy puja and becomes an eyewitness.
But in India, I have noticed WhatsApp, someone dying on the road, people are walking, they're not bothered about that person.
They don't come and appear in the dock also, my lord. They go and they go forever. They go and go forever. They don't take so keen interest. If it is because these are known people. If it is that I know accused, I know deceased, if my friend dies in front of me or any of my locality people, my lord, at least, my lord, I'll not go, thereafter, I'll not go to Puja Mandap. I'll be going, I'll try to help you.
Pray for the death soul.
Now that's the issue, my lord, maybe. That's,
You are also maybe. Everything is maybe.
no, my lord, if there
He
is,
might be a very holy person, but I must pray for his soul, poor fellow. Might be a good soul. PW10.
huh? Now my friend is whispering in my ears that he is such a holy man, he even did not thought it prudent to inform his own family members, though he is a known man. Well, these are the things how we discuss.
He's a holy crook. That we say.
Holy crook.
Holy crook. Pretending to be holy.
In Hindi they say Gyani Papi. He's Gyani, but he's a sinner.
Ah.
So
A lot of people are like that. No, they show something to the public while actually they are different character altogether.
yeah.
So similar.
So, my lord, these are the things, because in some of the Supreme Court judgments which I will rely, my lord, we have seen that these are the conducts, my lord, which the Supreme Court has taken into account to discredit eyewitness. Normally, a person will not behave in this manner unless he is a very obdurate and very hardcore, my lord, person who can withstand all these miseries with or less, no action. I mean, no reaction, no emotion. Only those rare of the rarest sort of people can react in this manner, the way these eyewitnesses are narrating. After that, they went to. And my lord, one more thing which my friend during this break was telling me, and I found it, my lord, that he's, relevant, that your lordship has said that because in this case, none of the eyewitnesses are, my lord, have deposed to have seen the presence of other eyewitnesses. None of the things. And their lordship is have given an example that in a cricket match or a football match, my lord, he has correctly said that in a cricket match, we go with a predetermined mind to see the cricket match, not to see my neighbor. But here they have not gone with a predetermined mind to see a murder. Murder happened instantaneously. Suddenly came within a fraction of seconds, this incident happened.
She was not telling about the whole cricket match. Lordship was telling about that particular over.
Because, my lord,
Over.
absolutely, my lord, because then we have a preconceived notion with an idea that I'm going there to see this. So my entire whole attention is focused there. But here is a case where my attention, because I have not come here to see a murder which will take place within 3-4 seconds. So naturally, I'll be aware of the vicinity. I'll be aware of the people who are around me, because there are hardly 7 people.
Supposing the incident occurs 10 feet away from me. And there is one person looking at the same incident from 60 feet away. Is it possible that I might not notice that person who is behind me 60 feet away?
My lord, had there been, my lord, we'll just see that.
You see, it depends upon a lot of
My lord,
things. It doesn't mean that everyone will be around 10 feet.
my lord,
Some may be 40 feet, maybe 50. Some may be behind the tree. Some may be behind the house. So
now, my lord, this maybes has to be somewhere there in the evidence.
Maybe.
This maybes has to be some, because, my lord, there is a 5-judge judgment which says that maybe and might be. This distance, your lordship has also read that judgment. This distance has to be traveled.
You have to give me all those. I have got zero knowledge.
That distance has to be traveled from maybe to must be with credible evidences. Because, my lord, had it been a case of 2 eyewitnesses, one on the east, other on the west, I can understand this logic. Had it been a case of, let me put 2 more, add 2 more, 3 eyewitnesses. There are 7 people. The directions are 4, east, west, north, south. There cannot be some other directions.
Northeast, southwest.
These are in between things.
More than 7, 8 of them.
My lord,
Just giving you.
I can't.
Trying to lighten up the load. Look, I understand your thing. But yes, you gotta think of possibility.
Because these 7 people, definitely, my lord, 2 people, one there, fine. 7 eyewitnesses. No one deposes the presence of the other. PW3 says, I called my mother. After seeing the incident, I called my mother.
We notice, we know. Anyway,
What was the issue of calling a mother?
next.
Next is this PW10, the brother. Now, he is another eyewitness whose presence at the time of the incident is not stated by any other witness, even his own sister-in-law, PW3, did not depose about his incident. About his presence. His PW3's own brother-in-law, deceased brother, deceased has three brothers. One died, one is the informant, and the other is this gentleman. Informant's sister examined as PW3 eyewitness alone, trying to take the credit of that. Even she did not depose the presence of this, his own brother-in-law. Forget about my lord others. Yes, PW10. Complainant Papu De is my younger brother. Deceased Pinaki was my brother. I know all the accused person. At about 6:30 p.m. on the day of Dashami of Durga Puja in 2013, I came out of my house to go to the Puja Mandap. At that time, I saw my younger brother sitting on a scooter on the road in front of the rear gate. Right at the time, accused 2 to 4 were keeping hold of the hand of my younger brother. Right at that moment, accused Bipul hacked in the neck of Pinaki by means of a sharp weapon. He was also assaulted on belly. Now this belly, there is, my lord, belly te to injury na? No, there is no injury in the belly. So there is something he's trying to, my lord, that half truth, full truth. The accused person.
Where is the injury? On the neck?
Neck and the chest. Chest. Belly. The accused person immediately fled therefrom. My younger brother slowly fell down to the ground. He got smeared with blood. Right at that time, PW11 and PW7 and PW6 came out. That is, he is belying PW11's claim as an eyewitness. He is belying PW7 claim as an eyewitness, and Dulal correctly, because Dulal, he is not an eyewitness. He is belying 11 and belying 7. Came out. Other people also came. We immediately took my younger brother to Lanka Hospital by an auto rickshaw. He was referred to Ham Hospital instead of keeping him in Lanka Hospital. We took him to Ham Hospital. My younger brother Pinaki died there. Police questioned me. My signature was obtained in the seizure list at the time of seizing 2 blood-stained glasses. Sample was collected from the blood lying on the ground, such and such, such and such. So, my lord, now Pinaki De was lying on the ground when PW11 and PW7 and Dulalnath arrived there. So the incident is over. After that, they came, PW11 and 7. Lanka Hospital is about 15 to 20 kilometers away from the place of occurrence. Doctor examined the injured at Lanka Hospital and later on referred him. Though it was dark at the time of occurrence, the street lights were on for the puja. The puja mandap is about 15-20 meters away from the place of occurrence. Munna, Krishna and Achinta had no weapon in their hand. I did not see them hurting Pinaki. Bipul came from the opposite direction. Bipul alone came by motorbike. Now this is a new introduction, my lord. So if we believe PW10, then we'll have to completely discard the evidence of the other eyewitnesses. So the point here is that prosecution have tendered an evidence to the effect that they were not together, because it's a case of common intention. That they were not together. I might hold the hand for so many purposes. It is their evidence. 2 to 4 might hold the hand for n number of purposes. Then Bipul came alone by motorcycle. You can argument give your method. You can argument develop.
Yeah.
I saw Pinaki being assaulted from a distance of 6-7 feet. I do not know the name of the weapon in the hand of the people as usual, but it was a sharp one. I do not know how long it was. It is not a fact that I did not state to police that Achinta, Krishna and Munna were keeping hold. So first time in court he is implicating 2 to 4. I do not know if there was any enmity between our family and Bipul. So no enmity, no motive attributed. I do not know if there was any dispute between the accused person and Pinaki. Even there was no dispute with the deceased. Police was not informed at the time of taking the injured to hospital. Police took my statement in the night of the day of the occurrence itself. I do not know the number of the scooter. I do not remember when I put my signature. Police did not seize the seizure list or read the seizure list to me. It is not a fact that neither Munna hold the Pinaki, nor it is not a fact that I did not see the accused person. It is not a fact that we implicated the accused person, bringing false accusation against them. Now the penultimate the so-called eyewitnesses, whose 11, whose presence was discarded by 3 witnesses. Already we have done, my lord. PW5 discarded his presence, 4 discarded his presence. His presence was discarded by 9. His presence was discarded by 10. Now he claims to be an ocular, what you call, my lord, an ocular evidence of the case. I know the complainant Pappu De and new victim Pinaki De. I also know the accused person. I was sitting in my shop at 6:30 p.m. on such as the day of Dashami of Durga Puja. Pinaki was sitting on a scooter on the day on the other side of the road in front of me. At that time, Achinta, Munna and caught hold of the hands of Pinaki and were pulling him backwards. Immediately, Bipul came. So Bipul came afterwards. Now, my lord, this pulling him backward is also a new addition, my lord, and caused injury on the portion from chest to belly of Pinaki by means of sharp weapon. The accused person immediately fled from the place of vehicle. Now, my lord, will see. He says that the injury was on the portion of chest to belly. Chest to belly, no neck. The injury which caused death, he doesn't say about that.
He says, later
on he says blood oozing out. The blood oozing out, my lord, but that has to be, there has to be some injury. See, later on he says, blood was coming out from the neck and belly. Blood was not coming. Even these are also two contradictory statements. Blood was not coming out from the belly because there was no injury in the belly. Which one to believe, my lord? There was no belly injury. He says, first he says it was injury from chest to belly. Then he says blood came out from neck and belly. Neither of these 2 statements are correct as far as this record is concerned, my lord. I'm just going by the records of the case. Blood was coming out of the guy. Then we all together put Pinaki in an auto rickshaw to take him to hospital. Later on, I came to learn that Pinaki had died in the Ham hospital. Police questioned me. I brought to the court for getting my statement recorded. All this skip. Cross. Achinta, Krishna and Munna came from the eastern direction of my shop. So Bipul and A224 were not together. This is the second witness who is saying this. Achinta, Krishna and Munna 224 came from the eastern direction of my shop. I neither saw arm in their hand nor saw them hurting Pinaki. Bipul too came from eastern direction. Bipul came on foot. Now some say motorcycle, some say foot. So only God knows which is correct. I do not know what weapon was in the hand of Bipul and of what shape it was. It was a small weapon. Pinaki was sitting on a scooter about 10-15 away from my shop. I was witnessing the incident from the shop. Now this is important, my lord. The next line. I neither stated to police nor in the statement made before the magistrate that appellant 224 were keeping hold of Pinaki from behind. So the statements which were contemporaneous in time, in those statements, my lord, he did not implicate appellant 224. So this is also, my lord, a fact which, my lord, mitigates the status of the present appellant as an accused in this case. Prior to the incident, I borrowed an amount of 15,000 from accused Bipul. I have not paid back the money. Sometimes people ask for the repayment of the money. So there is also an indication that maybe because of this, he has deposed against Bipul. Maybe an indication, but I am not for Bipul. Senior counsel will address my lord on Bipul, my lord. It is not a fact that I borrowed money and Bipul and he has been asking for the repayment of the money. I have adduced false evidence against the accused persons. It should be, it is not a fact. Yes, it is there. It is a comma. I read it. It should be, my lord. About 4 or 5 persons came to the court prior to me. The statement was read over to me. It is not a fact that I made false. Now, my lord, about 4 or 5 persons came to the court prior to me. The statements was read over to me. That is why I said, my lord, these 2 mantras were given to these witnesses. 2 to 3 holding, 1 stabbing. Rest all, my lord, they have, I mean, they don't corroborate rest of the thing. Only these 2 mantras were given. Go and depose this. Rest you make your own story. It is not a fact that I made a false statement before the magistrate. It is not true that I did not state to the magistrate that Pinaki was sitting in front of my shop at the time of the. It is not a fact that I did not state in the statement before the magistrate that Ochinto such and such was pulling and pushing Pinaki. It is not a fact that I stated neither to police nor to magistrate that the portion from chest to belly of Pinaki was cut. It is not a fact that such and such were not keeping hold of Pinaki from behind and Bipul did not cause injury to them. It is not a fact that I neither saw the injured at the place of occurrence, nor did I say Pinaki sustained injury. So, my lord, from the evidence of PW 11, my lord, firstly, PW 11 as per PW 9 and 10, he came later. According to him, injury is from chest to belly, which is not corroborated or supported by the postmortem. He in chief says sharp weapon, whereas in cross he does not know what weapon was in the hand of Bipul, but he says it was a small weapon. He had neither implicated appellant number 224 in his statement under 161, nor did he implicate 224 in his statement under section 164. And then he borrowed money from Bipul and there were some monetary transactions. Google 11. So, my lord, with this, the eyewitnesses, he was the last eyewitness, the eyewitness. So, my lord, what is common in the depositions of all these eyewitnesses are this. None of them could identify the weapon, despite being in such a proximate distance.
Yes.
2. Appellant number 224 had no weapon with them and they had not assaulted the deceased. These are common things.
Yes.
3. No eyewitness had testified the presence of the other despite there being 7 eyewitnesses. Five. No motive is attributed by any of the witnesses, eyewitnesses. Rather, contrary statements were made to nullify or negate even a remote possibility of motive. Contrary statements are there. Next. Modi on medical jurisprudence. Now, my lord. One more common thing. All the witnesses said sharp weapon was used. Sharp weapon, pointed weapon, sharp. This is common. That sharp weapon was used, though they could not identify or they could not. Now, my lord, we'll kindly come to the post-mortem report. Page number 120. I'm going by what the PP has said. 119, I suppose. It starts from 119.
No, you have to go as per the PP.
Yes, okay, my lord. My lord, we are, my lord, deeply obliged. State, my lord, we are subjects, they are the state. Now, my lord, will kindly turn to page 120. She is correct, the relevant is 120. Wound's position character.
Yeah.
Deep, clean cut laceration around 15 cm. Length lying transversely at the root of the neck front side. So it is lacerated wound, laceration. Yesterday, my lord, I was trying to find out whether with sharp weapon lacerated wound can be, I mean, whether a person can sustain lacerated wound with sharp weapon. I could lay my hands on Modi on medical jurisprudence. I'll just give that relevant page to your lordship. And the book, I've got a printout from this, my lord. Chapter 24. '24th edition, Modi on medical jurisprudence and toxicology. It is the 24th edition of 2011. And I am relying on page number 526. My lord, no, my lord, lacerated wounds just below that that bracket.
Yes.
Yes. Lacerated wounds are tears or splits produced by blows from blunt objects and missiles by violent falls on hard projecting surface. It can also be by violent falls, by machineries and railway accidents, by the wheels of a vehicle causing a grinding compression by their weight resulting in avulsion of the skin. They can also be caused by claws, teeth, or horns of animal, and by projecting nails or by overstretching of the skin over broken bones. These wounds do not generally correspond in shape or size to the weapon producing them. Their edges are torn, jagged, irregular, and swollen or contused. So it can. Therefore, my lord, I'll back it with the judgment of the
So
Supreme.
you are saying that it cannot be done by a knife.
I am saying it cannot be done by a knife, yes, my lord, by a sharp.
Okay, what if not a sharp knife? What about a blunt knife?
Blunt knife, my lord, in one cut it cannot be.
How do you know? Have you ever tried?
I tried cutting apples and other things. With blunt knife, my lord, yeah, if I give a blunt knife to my wife, my lord, he'll not be able to chop vegetables.
How do you know?
How do I know, my lord?
Have you ever chopped vegetables with a blunt knife?
It's my lord, the sort of sharp and one slit. It's not that 2, 3. One slit. It has to be very sharp, my lord. Normal course of my lord, things has to be understood in its normal character.
You are in Nagaland. You must have used some
Nagadao.
knife at times.
There it is called as Nagadao. They keep it here.
You see, dao is not the only thing. When you cut thing, you don't use dao. Dao is only used for the big pieces. For the small pieces, you don't need big dao.
My lord, my whole
It's
point.
the same in the all the other tribal areas also. We also have.
Recently, last week, I was there in your place for 3 days. My flight got cancelled. 18 hours journey by road.
By road.
Silchar and then Silchar Haflong
And
road.
road is bad.
My goodness, terrible. There was landslide also.
Haflong, how's the Haflong road?
Haflong, from Silchar, I came through Haflong. Haflong road, 25 kilometer is terrible. Through Jhatinga and all this, 25 kilometer is terrible. Terrible. I mean, we can't pass two tracks. We'll have to, we go, if some car is coming from the other side, we'll have to go back, give side and then again. That was the condition.
You went by car?
I came by car because my flight got cancelled and I have to reach.
No, there's no Scorpio or some four-wheel.
No, I came by Scorpio from Aizawl to Silchar Scorpio. From Silchar, I came by Innova.
Okay. Anyway, so this wound cannot be caused by a sharp weapon.
The type of injury which is and that
wounds cannot be caused by a sharp
lacerated injury,
blunt object or by a
nails, club,
teeth,
teeth also.
Teeth, horns.
This is what my lord Modi says. I am not a student of medical science, my lord. This is what Modi says. Now, this is backed by one judgment of the Supreme Court. Para 3. 1987 2 SCC 232. আপনার দুটো সাইট এখানে এটাও পাওয়া নাই খালি যে দিছিল it para 3 it could not be doubted that the injuries in the nature of lacerated wound or contusion could not be caused by an impact of a sharp-edged weapon on a human body. Such injuries are only possible by use of a hard and blunt object. Maybe that the spade was the instrument of an offense, but it might have been used in a manner in which the hard and the blunt part of it came in contact with the body of the injured person. In view of the nature of the injuries sustained on the complainant and the conviction of the appellant under 326 IPC could not be sustained. At best, he could be convicted for an offense under 325 along with special leave petition. Along with special leave petition, an application for compounding has also been, those are not able. So the point here is that, here also, my lord.
I doubt if, with due respect, I doubt if they've ever used a blunt knife. I doubt if they've ever used a blunt knife. I doubt.
No, my lord.
You see, because teeth can cause lacerated wounds.
Yes.
For this Modi. Modi says here.
Yes.
Teeth, claws. So when you use a lacerated, use a blunt knife, there are lacerated wounds because you've got to give extra force and it doesn't cut clean. The clean cut is never there.
My lord, the opposite of blunt is sharp. If I go by English language.
Correct.
If I go by English language, then the opposite of blunt is sharp.
Yeah.
The evidence on record says.
Evidence on blunt is sharp, correct.
The evidence on record says sharp.
Sharp.
The evidence on record says I cannot presume it to be blunt.
No, but then when the weapon is not found,
it further damages prosecution case.
I don't know. We'll have to. Where does it say sharp? Where does it say sharp?
Everywhere, my lord. All. Top to bottom says sharp.
It's a common man, my
Top to. No, look, common man, uncommon man, all men are common, my lord. There is no uncommon man, my lord. Yes, there is common sense and.
Cutting can also have teeth. Sharp cutting side can also have teeth, my lord. Yes.
Sharp cutting side may also have teeth.
Yes, switch, my lord. Yes.
That he's talking. He probably is talking about saw. That.
No. Small. Yes.
Like one third is sharp.
Yeah.
And then,
Yes.
But then 2/3 is sharp and 1/3 is.
Yes.
What is the right lordship with teeth? Correct. I use
Anyway.
No, my lord. Can these arguments supplant what is being stated by the accused? I'll show what is stated by the accused. Stated by the witnesses. I'll just pinpoint. Ulasan is sharp for the quote exactly like
That is there.
that is there. these arguments will not supplant what is there on record, my lord. I cannot go and manipulate words and, my lord, this has to be maybe, and more maybes, more chance of acquittal.
Very good for you then.
That is precisely, they are helping my case.
So let them help you. Why you want to deny them?
They're trying to justify things which perhaps apparently are unjustifiable.
As long as it helps you, how does it matter?
So, my lord, because as your lordship has pointed out, my lord, the evidence came out, it is sharp. So I will go by what the evidence has come. So now, my lord, to presume that probably the weapon was blunt.
So you agree with the evidence
Yes.
that it was a sharp weapon used. But they were not supposed to be there according to you.
That is precisely what I'm saying, my lord. That because, my lord, they will have to prove the case. I am trying to demonstrate a case where there is no.
Either we accept their evidence as a whole or we don't accept it at all.
At all.
So that sharp or non-sharp also is not proven according to you. Then if they are not there to see it, how could they say whether it was sharp or not?
No, my lord, then, my lord, how do I discredit a witness in that case?
I don't know. You tell. It's your job. My job is only to listen.
No, if your lordship is saying that
you said your entire submission has been that they were not there.
Yes.
They were not there at the scene of the crime. So how could they say that it was sharp if they're not there?
My argument is this, that they were not there and therefore they have given a wrong description of the weapon.
That is why they have given a wrong description of whether it was sharp or not.
Yes,
sharp.
yes.
So it might not be sharp at all also.
But must not be sharp at all. So they're lying. Precisely. Your lordship has I am deeply obliged, my lord. That is precisely my argument.
Okay.
That they are lying. Which is fortified by the fact that they are saying a sharp weapon, whereas the doctor say lacerated wound, and your lordship said it can be by a blunt weapon. So if it is by a blunt weapon, what has fallen from your lordship, then it further strengthens my case that they are lying.
Okay. That doesn't really strengthen, but okay, we'll accept it.
No, my lord, I am just being logical, my lord. What has fallen from, I
see, what I'm saying is, there is evidence to the effect that it was a sharp weapon.
Absolutely. Pointed and sharp.
Pointed and sharp. Now, if the witnesses were not there, according to you, the witnesses were not there. Eyewitness. So the question of pointed and sharp does not arise. That's all.
Then I am also not there. Because I am.
That's what I'm saying. If you're not there,
then I am also out of. Then
why are we dwelling on the subject of pointed and sharp when you were not there at all? You didn't know. I mean, they didn't know.
Now, my lord, I say.
So they didn't know. So what they said regarding pointed and sharp is all bakwas since they were not there.
Then my case, then my lord, I need not make any other submission.
That is your case.
That is precisely. I am what I am trying.
So we do not know whether it was pointed or not pointed, or sharp or not sharp. We do not know.
My lord, my understanding is this, subject to what your lordship says. My understanding is that these people are lying.
That's what
these people are lying.
That's
so the fundamental, now all these lie culminate into one fundamental thing. To prove my entire endeavor is to show that they are not eyewitness. And therefore I am saying, therefore, because of a point, this point, that point, and one such point is this injury. Okay. Even their evidence with regard to weapon, whatever little bit they have given, even that is nullified.
Okay, next.
Now, my lord,
Yes.
Suppose your lordship gives a benefit of doubt to the prosecution that the identification is correct.
Cannot give to the prosecution.
Oh, sorry.
I have to give to you.
I mean, my lord, I'm sorry. Suppose your lordship does not agree with the defense that the identification is correct in the doc or not doc TIP. Suppose your lordship is not convinced with my second limb of argument that there are such inherent and palpable contradiction between the eyewitnesses that they cannot be relied. Suppose your lordship even brush aside the wound and lacerated and sharp weapon which they have which has come up on the, which has been in the records. Let me presume for a while and not admit even for a moment that all this prosecution at 200.
If you presume, that means you admit.
No.
You presume that it is correct.
I presume that it is correct.
Then you admit for a while only.
For a while. I presume for a while that all these are 100% watertight case for the prosecution. Until now, watertight case. Then my argument would be whether under such circumstance, when two persons are holding hands and one has stabbed, can those persons who are holding hands can be convicted under section 302 with the aid of section 34? My lord, I'll not make submissions on what section 34 essential ingredients. These are, my lord, your lordship has rendered thousands of judgments, my lord. We have been also reading it for last 2 decades, my lord.
That is exaggeration, not thousand.
Maybe, my lord, whatever number, my lord. We say 100%, and nothing is 100%. Those are, my lord, colloquial language, my lord.
Yeah, you are adding a little bit more.
My lord,
TTM.
my lord, 100 judgments.
TTM.
I'll reduce one. I'll cut 1 0. I'll cut 1 0. I'll cut 1 0. My lord, common intention, my lord, premeditation, then premeditation can be at the spur of the moment. It is not required that it has to be from a prior point of time. It can form at the moment. All these are, my lord, tried, settled, time tested. Therefore, my lord, I was searching a case that on similar circumstance. Then only, my lord, probably my argument will have some force. I must give credit to one of my friends, Sarfaraz Nawaz. He has given me this judgment yesterday.
Okay.
I should not take credit of this judgment.
Why not?
He has, in fact, helped me in getting, I was just sharing.
When some person runs 100 meters, the coach gives him all the training. All the credit at the end of the day goes to him. Gold medal cannot be shared. It's only given to the winner, not to the coach. He only gets words of praise. That's all.
That is what.
But
So
all the accolades go to the winner.
I hope. 1999, Volume 8 Supreme Court cases.
1999.
Volume 8 Supreme Court cases, 555.
Yes.
Para 3. I rest my case here. If an inch of the fact is different, I will not make a single submission. Here also 2 persons were holding hand. How can be more identical effects be? And they were convicted with the aid of section 34. Supreme Court said that no, gentleman, he might have caught hand with an intention so that the third one will slap. But the third one step. They might have caught the hand with an intention that the third one will give a punch on the nose. How do you know that they are sharing the intention that he will come with a weapon because he came in a motorcycle? Coming to the question of applicability of section 34 for the murder of Tapeshwar, we find from the evidence of the 3 eyewitnesses that while Ramprasad Yadav and Ramchandra Yadav caught hold of Tapeshwar, accused Samudra Yadav and Sheolakha Yadav came with Gandasa and gave blows on the head of Tapeshwar, as a result of which Tapeshwar died. Section 34 lays down a principle of joint liability. 2 persons were holding hands. Laid down the principle of joint liability in the doing of a criminal act. The essence of that liability is to be found in the existence of common intention, animating the accused, leading to the doing of a criminal act in furtherance of such intention. The distinct feature of section 34 is the element of participation in action. The common intention implies acting in concert, existence of a prearranged plan, which is to be proved either from the conduct or from circumstances or from any incriminating facts. It requires a prearranged plan and it presupposes prior concert. Therefore, must be prior meeting of mind. The prior concert or meeting of mind may be determined from the conduct of the offenders unfolding itself during the course of action and the declaration made by them just before mounting the attack. It can also be developed at the spur of the moment but there must be prearrangement or premeditated concern, these being the requirement of law. For applicability of section 34 IPC, from the mere fact that accused Ram Prasad Yadav and Ramanand Yadav came and caught hold of Tapeshwar, whereafter Samudar and Shilo came with Ganesha in their hand and gave blows by means of Ganesha, it cannot be said that accused Ram Pravesh and Ramanand Yadav shared the common intention with the accused. And these two were acquitted. They were acquitted of the charge.
But here the facts says little bit different.
Absolutely.
Little bit.
The factual part,
They were holding hands, my lord.
factual part, there was an altercation between them.
And there was a previous, warning also.
The factual part,
Yes.
there was, at that point of time, there was an altercation.
But here also, my lord, the entire point here I am trying to impress on this court is this, my lord.
See, when two people meets and there was an altercation. When somebody comes and hits somebody,
Yes.
that's on the spur of the moment. So premeditated aspect may not be there.
My lord,
But in your case, a little bit different.
my lord, what I am trying to say. Premeditation can develop at the spur of the moment, at that very moment. Also it may develop. That's, my lord, there are plethora of judgment on that regard, my lord, that it is not required that it has to be 2 days back or 3 days back. Here is a case, my lord, absolutely identical in my respectful understanding, identical to my case, where these two gentlemen has caught hold of the hand, maybe altercation, my lord, here also there are evidence of some altercation. They say that one witness came and said that why you beat my this and that, which I have shown.
No, that is not there.
Which one?
Altercation was not there in your case.
Therefore, my lord, my case is a better case. My lord, if there is an altercation, it lends some motive. That he will have some motive, some common intention of killing. That some intention of killing. That there is an altercation. If there is no altercation, then it becomes a better case.
No, you are arguing on 35, 34.
Absolutely. I am arguing on 34 that only because two persons were holding hands, that is what precisely, Ram Yadav and they were holding hands. Now, just for a moment, if your lordship keep aside this altercation part, just for a moment, I'll come to this altercation. The fact remains, two persons hold, the third and the fourth person came and hit the head of the deceased and they died. Now, whether there is now altercation, your lordship is probably indicating that it is a heat of the moment, that suddenly heat of the, because altercation, if altercation is the, I mean, my lord, if altercation will distinguish, then it will distinguish in my favor. Because altercation, if there is an altercation, there may be some motive for those two. But if there is no altercation, the altercation part will be interpreted to my limited understanding in my favor.
Correct. That's perfect.
I am deeply obliged, my lord, because that altercation, if there is an altercation, even then if Supreme Court says, then my case is far better than this case.
Okay. Next point.
And one more judgment he will rely, my lord, that somebody was holding legs and that section saying. He will rely during his submission.
Why give us a separate thing then? Because
I will rely on 3 points. I will not take much time, only 45 minutes, not more.
Yeah, for
2 and 3.
Okay. Tomorrow. Tomorrow. Tomorrow we'll try to complete everything.
And my lord, I have 1 or 2 points.
Oh, you've got?
Yes, my lord.
I thought you finished. You said
no, because there is 2 more important things.
We'll complete.
One or 2.
Train of thought is still there.
Yes. So my lord, in a case of this nature, where there are
more 10 minutes.
10 minutes, my lord, I'll try to finish it 10 minutes, my lord. 10 minutes. I'll try to finish.
Because they have said basically all.
Absolutely. Now, my lord, in a case of this nature, where there is no, where there are significant inconsistency inter se, among the eyewitnesses. In a case of this nature, where the weapon is missing, in a case of this nature, where the medical report does not support the injury from a sharp weapon, in a case of this nature, motive assumes some importance. I am not trying to make a submission that in a criminal trial, the prosecution will have to prove motive to bring home the guilt. Not in all cases. Where the evidence are clinging, where there is unimpeachable evidence, where everything points towards the guilt. In those cases, motive is not important. But in cases where the evidence are shaky, 50-50, either be, 50-50, where there are sufficient doubts, some discarding the presence, one discarding the presence of all, 4 discarding the presence of this. In such cases, it is incumbent on the prosecution to give a motive. That, my lord, nobody kills a person.
You see, yeah. It's like now we're listening to some preacher
No.
giving us lecture.
No. That's my lord. I'm just making submission. A lot cost to it.
You have said everything basically. These 2 hours, you have said everything that is required to be said.
Absolutely.
More than 2 hours.
Only one judgment on motive, my lord.
Go to the point.
One judgment, 2007, 15 SCC 545.
2007.
7, volume 15, SCC 545.
On what point?
Right. That motive is required, my lord, in cases where the evidence. Para 8. In the case of prosecution that the other 2 accused, namely Satyajit, has motive against the deceased and the respondent had no motive whatsoever against the deceased. All the 3 accused were friendly among them. It is true that 1 to 4 have supported the prosecution case, that all the 3 accused went to the house of the deceased on the date of the incident, and the respondent called the deceased to attend a patent immediately. I'll just come to the relevant part. It is generally vague. No specific overt act is attributed to the respondent. It may be mentioned here that there are no recovery of knife. Same case, in this case also there is no recovery of the weapon from the respondent. There was recovery of blood-stained cloth from the accused. Chandra, it is not possible that on the accused such and such asking the respondent to accompany them to the house of the deceased to show a patent, or the respondent himself might have taken a patent also for examination by the doctor. Mere presence of the respondent on the spot when the incident took place was not sufficient to hold that the respondent had shared the common intention to kill the deceased, particularly so when the respondent had no motive whatsoever.
Yeah.
And I have 6 minutes, so I'll just see. My lord, no, I'm just going by what your lord.
No problem.
Now, my lord, under section 114, illustration G of the Evidence Act, it says that tender the best evidence, and if you do not tender a evidence, then the presumption would be that if you tender that evidence, it will go against you, which we say adverse inference, in short.
Section 140.
114 illustration G of the Evidence Act. This new BNS, I do not know, man. That I'll have to verify, but this is there.
So we are always referring to the old section.
Yes, man. Old is gold, the old saying.
But then they'll be thinking, ignorant judge and ignorant lawyer. So you please find out the corresponding section. We have got to show that we are up to date also, na? At least pretend. That we are up to date.
The first thing, it becomes very difficult for me to give this pronunciation. That Sanitha Sindhi.
You just give the form.
Absolutely. Now, my lord, on what aspect this adverse inference in the present case can be drawn? Hareshwar Shoikia and Himade, whose houses were just adjacent to the house of the deceased, And there was PW3, according to him, he screamed. He called his mother.
Not he.
She, he and she only. She, about once and done. She. But General Clauses Act says he will mean she and she will mean. There is one, I think there is something in General Clauses Act. Yes, it is there, man. Adverse inference. So Hareshwar Shoike and Hima De, prosecution doesn't examine them. Just adjacent. Then
That to even Mr. Kamar has said.
Tapan Shaha, whose shop is opposite to the place. If in the sketch map, your lordship will see the B point, B shop.
He says Tapan, he says the shop, but it is somebody else's shop.
No, Tapan's name figure out.
That in his evidence, he says that his shop was opposite to the place of occurrence.
Shibu Shaha, not Tapan.
Shibu Shah.
Tapan's shop is opposite. He has not been examined. Yes. Then auto rickshaw driver who carried this man, he would have been the best evidence to say who all were there in his vehicle.
Maybe no one took down his auto rickshaw number.
Then again, the maybe part, my
Correct.
maybe. So with maybe if a person can be convicted under 302, I have no submissions.
No, this is with regard to carrying someone to the hospital.
Then all this will add up to the extreme. I'm not making a, this is
The auto rickshaw driver did not see the incident. He only carried a person to the hospital.
correct. Because there are,
So his evidence will not show anything, only to the effect that who he carried.
and that will, because there is a link with that in oral dying declaration, because the oral dying declaration was made in his presence in the auto rickshaw while he was carrying. Those Mr. Kamar, he will make those submissions. My lord, I am just dying declaration.
Dying declaration, we don't know if it can hold up in
It will not hold up. It's a very, very weak piece of evidence. There are a lot of judgments. I'm restraining myself from going into that arena because I have kept it for Mr. Kamar, my lord, senior address. No person from Lanka Civil Hospital, where he was first treated,
Yes.
was examined. Not even any.
Do you know he was treated?
It is the evidence. He was taken to Lanka Civil Hospital from Lanka Civil Hospital.
Does it say that he was treated in Lanka hospital?
My lord, he was taken to Lanka Civil Hospital.
Taken doesn't mean treated.
My lord, I'm yet to complete the sentence, my lord. He was taken to Lanka Civil Hospital. After initial checkup, he was referred. He was referred to, that is what IO said.
Does it say checkup? Was he checked up? Does it say
My
checkup?
lord, how can without checking up somebody may refer, my lord? I don't know.
That also you are saying maybe now. I'm asking you, you have got to show
My
me
lord,
the
my lord, if somebody goes with a stomach pain to a hospital, he will not refer him.
Correct.
So once he refers, something he must have seen. Something. Without seeing anything, he will definitely will not refer. Yes. 2 minutes. Okay. So, my lord, these are some, my lord will just note down the page numbers because there was a page numbers of the paper book. There was a plea of LEB. And when my client was appellant number 4 were examined under 315, I exhibited certain documents to show that I was not physically, because my right leg got operated. I met an accident. My right leg was operated in Patna. I was under treatment from 1/4/2012 to 1/4/2012 to 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 09/05/2016. And I am not making these submissions without any documents. All the medical documents, there was this motor accident claim, the record of the motor accident claim. My lord, I'll just give the page number because within 2 minutes. Page 172 of the paper book. These are exhibited documents. These are not, I am not annexing like read petition. My lord. These are exhibited documents. 172. Then undergone surgery in 2014, 218 page number. Then right leg fracture, 192 page number. because he met with an accident. There are, my lord, judgments of the Motor Accident Claims Tribunal where he was paid compensation. There are surgery reports.
Discussion. Was there any discussion on this?
Did you take up this plea before the trial court?
Absolutely. Exhibited documents, my lord. Exhibit, that is why I said.
You want to say that you were not there at that time?
71 is the defense witness. He has examined himself as a defense witness.
Yes, that is what I said. While I was examining, when I examined myself as a defense witness under 315 CRPC, all these documents I have exhibited. All these documents I have exhibited.
So you were not there, according to you.
I took the plea, according to me and according to the prosecution witness, which is why none of them has identified me. Not even a question was put to me whether I know the witnesses or not. Vis-a-vis who are the other appellants. Same day, other appellants were asked this question. I was not asked this question. Well, informant issues. But only 60 seconds informant can give, bear with me for, otherwise I am, informants, time and again the informant. Assisting through the PP to whatever little I understand. Whatever little I understand. Man.
It is not a trial.
No, trial, appeal, principle is same. Principle is same.
Basically, you are saying that you were not there. We'll have to see that.
That is also one of those, man. One of those.
You are basically saying that the document that you have exhibited show that you were not there at the place of occurrence on that relevant date. And it was because of this very reason that none of them have identified you.
My lord, I just may not be exactly what I'm trying to say. What I'm trying to say that the documents indicates that I was not physically fit. I was not physically fit, and therefore, my lord, the way this incident is narrated, I went, hold, pulling, and then suddenly running and jumping and whatnot. This is not possible. That is what I'm trying to say. Not that during that relevant point of time.
You were there, but you could not have done this.
I could not have done this. That is precisely. My lord, these all, my lord, I'm really thankful, my lord, at least 2.5 or 3 hours almost, my lord.
Yes, you have taken a lot of time.
So you were appointed 1 month before this incident?
No, I was initially the accident took place in 2012. The incident happened in 2013. Then I did not recover fully. In 2018, I undergone an operation. That is why.
The case number 72 also. He has admitted that when the police went to his house, he was not present in the house. As he is a bedridden patient, how can he be out of the house?
Well, bedridden, from where those? Those are by. अच्छा, ये discrepancy का कुछ था ना? हाँ?
Okay, right.
हाँ? ये discrepancy का तुमने जो लिखा था, ये
no one appears for the appellant number 1. Oh, you are there. Okay. Appellant number 1 is represented. Appellant, no, let's say the counsels for the parties are present. Mr. M. Biswas, learned counsel for the appellant number 4 has been heard. Appellant number 1 has not completed his argument, while appellant number 2 and 3 are I will give the submit that they will give their submissions tomorrow. List the matter tomorrow.
My lord, I'll just give 2 judgments to the court master. I'll write the para numbers, and on which point I'm giving, I'll mention that on the inconsistencies of eyewitnesses.
Okay, no problem.
Subject to what they say, if at the end of this, if any rebuttal is required, I'll give only that much indulgence. First, madam.
So tomorrow we will hear your the list.
After the rebuttal part, maybe after Independence Day, man.
Has to be.
Because tomorrow.
They won't complete, I don't think.
Because tomorrow, personally also, my lord, I have some problem. I'll go to Darjeeling tomorrow.
Oh, yes. Oh, he will not be there.
Tomorrow, Lordship, I also have some problem because my own cousin brother.
Okay, anyway, let me hear this so that we can have some idea.
Because I I have some prayer, Lordship, because my cousin brother died yesterday.
Oh, okay.
Like, my first cousin. He was
Anyway,
very
we will hear you. We will hear you. Let us finish. Let us finish you 2 and 3. I don't think you will take too long. No. And it just if 2 and 3 I'll hear. If you want to give a small point system thing, no problem. I'll accept that. Point system small. It should be point. No point because we have heard, you see, we have heard him speaking on all the evidence. Then we have heard Mr. Kamar speaking on all everything. He has spoken, taking us through the same. No point of taking us now. It's just a waste of time. We have
Which is why, my lord, I deliberately avoided this dying declaration because he has dealt with
Dying
this.
declaration he has dealt with. very
Therefore, I have not made it.
And it's slightly,
No point repeating.
might not be very relevant also. I don't know. You can give judgments if you want, but not going into the issue, reading out, no point. So, and Mr. Z Kamar will be free when? Tomorrow he is there? Yes. Okay, then if he can complete tomorrow, then we can, have at least finish it off. And then after that, when PP finishes, if they want to give a small rejoinder, it's okay. We'll see.
Tomorrow has first
Huh?
finish. Tomorrow has first hearing.
No, not first. There are a few part 1 matters that will finish within not too many, within 1 hour, within half an hour, 1 hour will finish. Then we'll start off with
Some of the points they have raised in minor, I have a right to rebut in minor. I level just small.
that will allow.
independent.
We'll see, madam. Tomorrow you are going to be here, no?
No, Lordship, I will be here, Lordship, till 4 if I'll be.
That's
Lordship,
we'll
because
finish everything.
After 4 I have something.
We'll finish everything. You see, the only thing is that there is a direction passed by the.
Yeah.
No, for that, Lordship.
We have got to respect that decision.
Yeah.
That is, and we have already crossed that timeline. So,
Appellant number 1, they went to Supreme Court for that bail.
no, but because of that, now timeline has been given. Now we have got to complete the timeline. Because if we don't respect that, then they'll come down heavily on this court.
Lordship.
And they say, what are these 2 High Court judges doing? They're not even complying with our orders. So, we've got to be careful. Okay. Chalo. Tomorrow, list the matter tomorrow.
बेंटू के एक्सटेंड कराइलो
Classes, can do that.